response. We've got at least Mr. Dunbar, as well as 2 other potential witnesses, Andrea Dennis, and those we filed those over the weekend and served the state with them over the weekend. I believe Madam Prosecutor has copies of those.
Yes.
At least 2 other witnesses that we anticipate calling.
Mr. Steele asked if he could have them all heard on the 29th, is my understanding. So we would simply ask that any motions be heard after Mr. Steele and Mr. Williams and Mr. Adams' experts are either qualified or disqualified.
Okay, I'll hold that one until. Okay, all right.
And Judge, when the state says a bunch of other lawyers that filed those, we're among the bunch. I'm just
Many.
sure that we're in.
Okay, sir.
Thank you. That's from Mr. Nichols.
Yes, sir. All right. I think we were talking about the motion to sever the counts. You said you're going to argue that, and we'll be able to argue that in just a little bit. There's a motion to sever this trial.
Can you pull up?
Are you prepared to argue that, soon as everyone wants?
Yes, those are all motions that Mr. Floyd wrote, but I know that the court wants to get those heard, so I can go ahead and do that.
What about the motion for bond after in-camera inspection of discovery?
You want to do that one? I can do it. Yeah, we can do that, Your Honor.
All right, so go ahead, Mr.
And Your Honor, we did actually get a speaker, so.
That's one. I have low confidence in your technical.
I have low confidence in mine as well, Your Honor.
Let's see if we can't get it done. Get that just a little bit. Okay, good. All right. Yes, sir.
Oh, yes, Judge. Your Honor, I don't. This court has never, to this day, had an actual picture of the nature of these charges as it pertains to Mr. Farley, because what we kept having is proffers that turned out not to be true. Your Honor, I know with Defendant Kitchens there was some back and forth about this, and we got into, well, it's a preponderance standard about how the judge used that. But
Yeah, it's a difference between it's a pretrial and also federal and state court. It's different in federal court.
Right.
Georgia hasn't gone that far. Proffers are acceptable in states or in criminal cases. It's unfortunately that's just the way that our systems, our laws develop in terms of that. So, is there anything more you wish to add to that, or?
Well, yes, Judge. I just want to distinguish Mr. Farley from Mr. Kitchens because I was there for that hearing, and I thought it did stand out to me because the proffers that have been made about Mr. Farley that led to a denial of bond in the last hearing turned out to just be flatly false in a black and white way where there's no gray area. There's just no gray area at all. Mr. Geary got up here and said, Your Honor, he tried to hide the phone and he tried to hide the gun, but we got him. And then I do a motion to physically inspect. He stands here to Your Honor's face and arranges a physical meeting for me to inspect the gun and the phone. And then 20 minutes later in the hallway, he tells me, oh, actually, we don't have a gun and we don't have a phone. So that whole dramatic allegation against Mr. Farley turned out to be flatly false. There is no gun, there is no phone, and Your Honor is about to hear those calls. I was ambushed by that, Your Honor. And so he's talking about jail calls. I don't know what he's talking about. Now I've heard them. They're just flatly not what he said. Your Honor is about to hear them. And it's just, there's no preponderance to weigh. Was there a phone and a gun seized from Mr. Farley that he attempted to conceal? No, there is not. And he doesn't even have a window tint violation. So he has no criminal record, no arrest record, never even been accused of a crime, presumed innocent here, can't be considered to reoffend because he's never offended before. How can you redo something that you've never done before? When you put re at the beginning of a word, that means do it again. He's never offended, and he hasn't offended here, and he's presumed not to have offended here, so he can't be thought to reoffend. He can't be considered a danger to the community. Your Honor heard from his principal that he'd never even been in a fight at school. So he's never been violent, has no risk of being violent. And then I would assume that Your Honor made the prior ruling based on a risk significant enough under Ayala about tampering. Because as far as a flight risk, he's never missed anything. He's never been accused of anything, and he's prepared the way the other defendants were to just be at home on an ankle monitor. These days, even the legislative notes about bond, Your Honor, say that we have technology that can make at-home detention on the same level as detention in the jail. And so, Your Honor, there wasn't any ruling, I thought, about him being a flight risk, but then it seemed by Mr. Geary's false proffers to the court that that was a denial. Also, Judge, I had asked for Your Honor to review in camera some of the evidence that the state's talking about, for example, the BP video, where they falsely tried to say Mr. Farley went in and greeted people at the store, when actually he walks in, sees the people at the cashier, and then purposely doesn't greet them. So again, that's not preponderance. There's no debate about that. He did not greet them in the store. And I wanted Your Honor to see that. I also wanted Your Honor to see some of these music videos where, first of all, I think ridiculous to attribute lyrics of art to real life, but even if you do, he's not even mouthing the lyrics in the word. He's a personal assistant to Mr. Wani Lee, the creator of the persona Slime Life Shorty, and he's there and he's in the videos. Personal assistants are always in the videos. That's a hip-hop trope, Your Honor, to have a video with you and your friends in your neighborhood. So he's not even saying the lyrics. I wanted Your Honor to see that. And there's even times in the video where he's like on his phone and Wani Lee has to like turn him around and be like, dude, we're filming a video. And so that's what I wanted Your Honor to see, because they were characterizing it falsely in their proffers. And so then Your Honor said, was that in your motion? I responded no. So that's why I did refile a motion so that Your Honor...
So that's a change in circumstances is what you want to consider?
No, Judge, actually, because there's never been a clear view of this situation as it pertains to Mr. Farley. The state, by the way they revealed discovery and mischaracterized it and said proffers that weren't true, robbed the court of all situational awareness to be able to see the nature of the charges as it pertained to Mr. Farley. So I'm not arguing a change in circumstances. I'm arguing that this court has never had a clear view of Mr. Farley as far as the nature of the charges, which is a bond factor, not the merits of the evidence. But the nature of the charges have always been mischaracterized. And when I tried to correct them, you'll remember Mr. Geary didn't respond to any of that. He didn't respond to any of my comments about the word slime and the fluidity of language and how language is context-based and my ideas about meaning and how they conflict with his ideas about meaning, but he didn't address any of that. He went straight to, well, Judge, sure, that's all true, but we got his gun, we got his phone, we heard him telling his girlfriend trying to get rid of it, but we got it, Judge. And that was false. And so, Your Honor, I don't think we need a change in circumstances. There's never been a time where the court got an accurate view of Mr. Farley and the nature of these charges to be able to analyze this under Ayala versus State, which importantly says significant risk, not just risk. And so, Your Honor, I don't think that the court's ever been in a position without an in-camera inspection of some of the evidence and without knowing now that what Mr. Geary said on the news directly to the camera was just not true. And now that's out there. So I want that out there that that wasn't true. And so Your Honor made a ruling based on things that weren't true. So we shouldn't need a change in circumstance. The only change in circumstance is that this is the first fair and transparent and honest bond hearing that Mr. Farley is going to have in this case. And I do want Your Honor to post a bond, to grant a bond, just in case we don't start on January 9th, Your Honor. And so we're willing to submit to any conditions, any kind of house arrest, any kind of reporting, any kind of ban from social media, technology. I mean, he can run his business through his assistants. He doesn't even need to have a phone, Judge. He can not have a phone and just sit in the house and report however Your Honor wants him to report, and tie an ankle monitor wherever we want to tie it. It doesn't matter. But he'll be monitored 24/7, and he's not a risk on any of the bond factors, let alone a significant risk. And that's been acknowledged, apart from that last proffer by Mr. Geary at the last hearing, that was just not true. And Your Honor is going to also hear these jail calls that were Mr. Geary's response to my proffers, and they're also not the way he said. And so, Judge, I just ask for a reasonable bond to this particular defendant in the amount of $50,000.
All right. Thank you, sir. Let's say,
Yes, yes, sir. Your Honor, well, first of all, I think your thing's still here. Okay. Your Honor, first of all, can everybody hear me? As to the, yes, I think we were transparent with the court before that Mr. Geary got the facts wrong. That happened. However, here's what he didn't get wrong. The jail calls are, I know Mr. Menendez, I respect him as, you know, what he's saying, but the jail calls are patently different than what he's saying. It's clear based off these jail calls, the only reason we did not actually find the phone and did not actually find the gun were because Mr. Farley arranged to ensure that we never found those items due to ensuring the phone was disposed of, that one of the guns was taken to Farley's family members. That's really clear from the jail calls. And so that's first of all. Not just, I don't believe the court needs to actually hear the jail calls to make. I just wanted to rebut that first of all. Second of all, Your Honor, Farley is currently facing murder charges for the murder of Mr. Drinks. He was incarcerated for Mr. Drinks' murder prior to this indictment. That was a brutal murder by gang members in a rival, in a gang dispute, essentially. Farley was seen at a gas station immediately before the murder. He was wearing YSL apparel with the word slime on them. He was with his co-defendants that murder at the gas station. That's like immediately before the shooting. Additionally, evidence shows that Farley was at essentially a YSL trap house, like a house where they commit unlawful activities. Within about 48 hours after that shooting, it was so recent, this shooting, that one of the co-defendants actually was still wearing the same clothes as during the murder. The state also has evidence that shows that Farley has some access to a cell phone while he's within the Fulton County Jail, and I attached this to our motion as State's Exhibit A. If the court has a copy of my omnibus motion I filed, it's attached to State's Exhibit A. It was located on, as recently as December 3rd of 2022. It was posted on an Instagram account that was named ysl.rude, and it showed a picture of Farley that appears to be, I don't know the legal term for it, but a selfie. It's where he's holding a camera and he's taking a picture of himself while displaying a middle finger. It appears that that photo was taken in the Fulton County Jail. Whoever created this post, presumably a YSL associate or sympathizer, posted this selfie of Farley with the comment, "Free the creator of Massa." I think, as Mr. Menendez agreed, Massa is the clothing line associated with YSL. It means the YSL slogan, "Make America Slime Again." Additionally, Farley's jail calls show that he has communicated with co-defendants through third parties. For example, he'd call a girlfriend of a co-defendant, they'd contact with that co-defendant. So for the reasons stated above, and additionally because the nature of this charge is a murder charge, in addition to all these gang charges, he was a participant in a very serious homicide, a shooting of a young man, only less than a year ago. We would ask that this court deny bond, but certainly we also would hope that the court will consider the jail calls as well, because I think that truly solidifies why Mr. Farley cannot have a bond. But additionally, Your Honor, there's been no change in circumstances, although the only difference between what Mr. Geary, he believed that the gun and the phone had been recovered. That was the only error. Other than that, everything he said was accurate, and the jail calls do reflect that Farley attempted to hide these items. He is charged for murder. And again, it does look like, whether or not he currently has a cell phone in his possession, that photo being posted so recently of a selfie, it's not a picture that someone took of him. It's clearly that he took of himself while giving a middle finger. It's attached as Exhibit A in the jail. Would support the denial of bond, Your Honor.
Just briefly, just on a couple of those things. Just the mere fact of facing a murder charge doesn't make you a bond risk. Otherwise, everyone that's presumed innocent and accused of murder wouldn't get a bond. And again, Judge, it's not YSL apparel. That's the part that Don Geary left unanswered last time. I don't want to get the state any ideas, but on the Make America Slime Again Instagram account, Mr. Williams is not the only one wearing the clothing. And Make America Slime Again has nothing to do with YSL explicitly. There's also artists like Future and T.I. on the Instagram wearing the same hat as Mr. Williams and that same shirt that Mr. Farley's wearing on the BP video, Your Honor. And the shirt says slime or die. It's just a play on words like trap or die. Your Honor, again, the state still by their proffer in a black and white way has failed to articulate any party to any crime. If you listen carefully to what Ms. Rosenwasser just said, all she talked about was presence and association. He's at the BP. He's with these people afterwards. He's wearing a shirt that has the word slime on it. Your Honor, Make America Slime Again is an LLC. It's an official company. It has nothing to do with just YSL. It was Mr. Farley's attempt to get any proximity to any artist of any kind of attention when attention is such a commodity these days, especially for the clothing business. And if you notice too, the shirts that Mr. Wani Lee is wearing in his videos, because Mr. Farley and him are close friends from since they can even remember, and he is his personal assistant paid by Alamo Records in an official way, Mr. Wani Lee is also wearing shirts from a different clothing line. I think it was True Detail or something like that, and it's some relative or other person that he's trying to put on. So, Your Honor, this is not YSL apparel. This is a person, an entrepreneur who is close to Wani Lee, has a business relationship with him, and then networks with musicians and other types of people to make his clothing more visible. And so, Your Honor, again, there's just presence, there's just association, and as far as access to a phone, that doesn't show anything. It shows that he's on the phone in the jail, but it doesn't mean that it was his phone. It doesn't mean that he posted it. That account that did the story wasn't him. You can reshare stories. You can post stories of other people. So just like when we had that proffer about Mr. Kitchens where someone said, oh, I'll do anything for Gunna. If someone wants to post something with an image that they somehow got because a camera from a jail phone was on Mr. Farley for a second and took a picture of him giving the middle finger, okay, he didn't decide to post that. He didn't decide to someone say free him or anything like that, Your Honor. So again, I don't see how being in a phone image makes you a risk on any of the bond factors, Judge.
I'll listen to the...
Okay.
I'm going to give the closing answer a minute. And the severance. So I'm not going to bless this about that time. So I'm going to take 10 minutes, and then we'll come back and I'll finish up with you. Thank you very much. Everything you said, right, thank you. Yeah, I'm still working on it.
I'm here, y'all. I'm just trying to figure out how. Well, I'm here, y'all. I'm just. They say they're about to come back in 10 minutes. I know y'all can't see me, but I'm actually here. I'm trying to figure out why the fuck my video, like, y'all can't see me. Hold on. Let me try to add another one. Fuck it. Video capture device. Let me see. What the fuck is going on here, bro? This OBS should be tripping. Hold on, gang. Hold on. My bad, y'all. My bad. Oh, so we on break. All right, they on break. Let me try to. I hope this don't kill my screen. Let me see. No, it's gonna kill my screen. Let me Google. My bad, I'm muted. I ain't know I was muted. My bad, gang. How everybody feeling today, man? We got them YSL boys in court today. He said I'm waiting on that new Gunna tape. You said Aaron. Who the hell is Aaron Dean? Let's see who the fuck is Aaron Dean trial? Put this on mute. Aaron Dean trial. What the fuck? Who the fuck is Aaron Dean? See, I don't know if I'm gonna support oh, that dude. Let me see. Is it on YouTube? That's that's that nigga, the police officer that killed that girl. I ain't really. Y'all talking about Gunna? Gunna at the house right now. Gunna don't give a fuck about shit. Gunna ass is at the house. Yeah, he killed that girl, right? They sentencing him. So the nigga got found guilty? So I like Gunna, but damn, G. Oh, she was pretty too, man. Nah, we still on break on Gunna trial. Look at this dude. So he must have been found guilty already, huh? JR, you said that happened in your hood. Where that's at? Where did this even happen at? Smash that like too one time. We only got 34 likes, y'all. We got 90 people in this bitch. Get them likes up, gang. Y'all know I'm putting in that overtime. I appreciate everybody that pull in, man. You hear me? They charging with manslaughter. Let's see. I don't even know the story. I just heard about it briefly about some girl got killed. I don't even know how it happened. I know nothing about it. Let me show that YSL ain't. Oh, fuck it. YSL back in court. We back. I'm about to roll up some reefer. Free the slime. Free the slime. Slatty. Oh, Fort Worth, Texas. Hey, one time for me, gang. One time for me, gang. One time for me, gang. Free thugger, free thugger. You hear me? Smash that motherfucking like. Look how my nigga Thug looking. He looking like a kindergarten teacher. Looking like old white women who read books to kids with them glasses.
Okay, all right. Ms. Rosenwald, I understand that your technology issues have improved.
I believe so. I think we just tested it. It's got a.
We'll find out.
All right.
Gonna be a meeting.
So this is the jail call.
This is number one, and I'd like to just be able to respond after each one.
All right, that's fine. Let's play jail call number one, please. Now.
Okay.
A free call from
Oh, these the phone calls.
an incarcerated individual at Fulton County Jail. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. Waiting to receive a phone call can be hard, but now you can easily and quickly send messages to your loved one. E-messaging is now available.
Boy, I do not miss hearing that shit. This is a call, GTL. I do not miss hearing none of that, boy. Free everybody who in that jam, because that's the worst shit, boy.
To help you stay more connected. Download the Securus app to sign up. To accept this free call, press 1. To refuse this free call, thank you for using Securus. You may start the conversation now.
Hello.
Yeah.
What's up?
You tell me.
What you doing?
Right. Huh?
What you doing?
Crying my eyes out.
You ain't got to cry, man. It's alright. These folks come out, I done shot and killed somebody, man.
What?
Yeah, they would just say on the thing, they say, accused. Like, they say, I'm the one who I don't know, this shit counts.
Yeah, so what the fuck? I can't. I'm confused.
Huh?
I can kill somebody.
What they do when I left?
They didn't do nothing. They came ask for your phone, but I didn't know. I didn't see no phone.
Yeah.
To get nobody.
You still got that number I gave you? You had not called my dad.
Yeah.
What did he say?
He said he called a lawyer, but the lawyer answered. He said keep him updated.
I need you to get Bob on number, man. So I can goddamn. No, hey, look, matter of fact, call Lexi, baby dad. If you know what I'm saying.
Call him and say what? I was just talking to her. Call him and say what?
Tell him, goddamn, hit breakfast. He know what I'm talking about.
Just say Miles said get bro for him?
Yeah. Send them folks down here.
Okay.
These folks trying goddamn murder, gang charges, and like they saying I'm trying to like get more ranking in the game. That's why I guess that's why the shit I did, whatever the shit they accused me of, he's like it's for initiation, like a higher rank in the game. Like that shit.
Yeah, it's tripping. Yeah, but that's why you just need to cooperate and do what you got to do to get on up out of there, because you have a son.
Yeah.
So you can't be thinking about nobody else or what nobody else got going on. You got to think about you, because don't nobody give a fuck about you but you.
Wanting to snitch.
You can't be thinking about what them folks gon'. I ain't trying to say, but
yeah.
You just need to start. You just need to think about M Day. That's all I'm saying. Think about him and yourself, baby. You can't be in there.
What you crying for, that?
Huh?
Why are you crying? Why are you crying?
I'm not crying. I'm not crying no more.
I need you to get that number from me, bro.
You acting like you want me to call on three-way or something?
Nah, hell no.
Okay, I mean, but how would you get the number? Like,
call on three-way.
This is number, number. Oh wait, let me go home. No, her number says so I can just add the call.
What else they doing?
Right here. Hold on, I'm calling.
You heard what I told you, what I said before I left? Huh?
Smash that like, gang. Smash that like one time. We only got 38 likes, man. There's 134 people in this bitch. Please, man. I'm trying to keep niggas updated, man. Listen, I ain't asking you for no money, none. Y'all even know my channel ain't even monetized right now. I'll be monetized in a couple weeks again. But please just smash that like, man. One time. Free thugger. You hear me? Free the slime. Appreciate everybody too, man. Smoke one for y'all niggas, man. Yeah, this is live right now. That was the phone call. I believe that was the call from. Hold on.
But I was just talking to her literally like right before you called.
You have 1 minute left.
I said, you heard what I told you before I left?
What you say? No, I didn't hear you tell me nothing. I love you too, man.
Don't let me fuck your day up, bro. Stop crying.
I was going to cancel my claim, but I'm going to keep doing it. I ain't going to go.
Hey, listen, I'm going to give you my Wells Fargo thing so you can go in there and sell this money to you. It's $1,200.
Shadow 5.
I got to give you the login, you know what I'm saying? So you can sell.
What? You didn't ever get that money?
Yeah, I'm just.
So when you going to give me the login?
I'm going to give it to you. I'm going to hang up and call it.
Oh, so you can call it. I'm thinking you ain't finna call it.
I'm saying, he said I can give you the phone, or they said I got court tomorrow at 12.
I know, that's who right before you called, that's who I was trying to get on the phone with to get the link. He said,
To get the
so I can send to you. The link, the Zoom link. So I can watch it.
Thank you for using Securus. Goodbye.
Bond
So, Your Honor,
That's call number one.
that call is relevant because of the context of the other calls. So what is notable about that call is, first of all, he discusses his charges, so I think that's always going to be relevant. And of course, the relevancy standard is really, really low. The question is whether this is in any way relevant, and it is. It's not, you know, the only evidence by any means that we have against him. It wouldn't be enough to convict him on that call alone, but it's relevant.
Let me make my junk smaller, bro. Let me make my picture, my screen smaller so I can see more of the shit. My bad, y'all. Just want to make sure it's right. Just want to make sure it's right for y'all. Damn, these niggas got, see, don't talk on them fucking jail phones, man. Don't, listen. That's rule number 1. You never talk on the jail phone about your case, bro. Never.
What's particularly important here is that in this call, the called party tells Farley that law enforcement came and asked for your phone, but I didn't see no phone to give nobody. So that goes into the next few calls we're going to hear. It essentially sets the scene for the remaining 3 calls. So if the court would allow us to play the second call now.
Okay, all right.
Call from
Wow.
an incarcerated individual at Fulton County Jail. This call is not private. It will be recorded and may be monitored.
telling you right
If you
there,
believe this
this
should be a
call is
private
not
call,
private.
please hang up and follow facility instructions to register this number as a private number. Waiting to receive a phone call can be hard, but now you can easily and quickly send messages to your loved one. E-messaging is now available to help you stay more connected. Download the Securus app to sign up.
To accept this free call, press 1. To refuse this
I
free
think this
call,
is
thank
him.
you for using Securus.
play his-
You may start the conversation now.
Hello.
Mm-hmm.
Hey, look, when I call, they hit 11111 so many times, you ain't got to go through all that. They going to straight accept the call.
Okay.
But goddamn, this shit crazy, bro.
Yeah. Them folks did tripping. I don't even, I came to the door with drugs on. I don't even put on my goddamn bra. I mean, I'm saying.
Yeah. It's alright, bro.
I can't hear you.
I say, you know what's up, though? Like, it is.
Yeah, but
Shit, cap it hell, man.
I know, but
Yeah, them courts don't play.
the police can make anything sound like.
Sorry if you bring no fuck to your house.
I mean, let me just tell you, look, I believe that's this his phone calls, because they got several phone calls, and they trying to say he was calling somebody, trying to send a signal for something, right? But you can't, they tell you in the beginning of the phone call, nigga, if your shit is being recorded, bro. Everybody know when you locked up, you never say no shit like that. You don't talk, you don't even, I won't even be talking about contacting nobody. That shit that you tell somebody else, that you got a 3-way message like that to somebody. You know what I'm saying?
Yeah, my mama with you. How the hell they get that address?
So I don't even know. Like, I don't know.
It's all behind the Carolinas.
Exactly. Somebody had to say something. I can't.
But goddamn, get what? Well, you said they were looking for the, it's in the, hairball.
Huh?
It's in the hairball.
So, Your Honor, I paused it there.
You heard what he said? He said they looking for the it's in the hair box. Like you talking too much, my nigga.
Over here, Mr. Farley said, so what they were looking for, it's in the hair box. That refers back to the call. And I do want to be clear that these 4 calls are all on the same day over a very short period of time. So he just said, so what they were looking for, it's in the hair box. We'll continue the call. I just wanted to flag that to the court.
Yes, huh?
Hair box.
Yeah.
Hair box.
Yeah, listen, do not cut that motherfucker on. Hey, like, go throw that motherfucker. Like, you feel what I'm saying?
What?
I even know what he talking about. He's talking about don't cut it. It's a phone. When he said, at first I thought I was thinking it was a gun. Now he said this. That's what I'm saying. You gotta. If you're gonna talk like that, you gotta say it so clever that we don't know what the fuck or don't say it. I would say just don't say it, bro. Right? Tell somebody else to tell one of the niggas that you locked up with to tell his girlfriend to call your girl and send this message. You see what I'm saying? You don't send the message yourself. Hey man, can your girl send a text for me real quick? Hey, you know what I mean? You don't. Hey, what they looking for? Don't cut it on. He talking about the phone. Don't cut it on. Throw that bitch in the. You see what I'm saying? Trash. You see what I'm saying?
So, Your Honor, that's where the defendant said, "Do not cut that. Go through that," and that is obviously Mr. Farley's contention was that was because he believes it contains unsavory character evidence. I believe that the jury could interpret it as the state has, which is that the phone would be evidence that the police were seeking. So we'll continue with the call.
I even knew what it was, and I didn't even know what it was.
Okay, man.
Yeah, you ain't hear them folk outside.
You know what they were saying?
They was at the window and shit. I heard them. Like, I ain't really want to get no sleep though.
You heard what they were saying?
They was like, we finna come in and shit. That's why I woke you up.
You woke me up? I don't even remember. I just remember this and screaming.
I had no grab MJ.
Yeah.
Man, that shit crazy, bro.
This shit is lame. What the fuck?
I'm saying though, I ain't finna keep going through this shit with you though, bro. Like, hell no. I got a little boy. I'm smiling like all that back and forth shit what we be going through. Like,
That's you, man. Like,
you really with a nigga though, but you know.
We got less. You want me to answer?
Yeah, hurry up and answer right quick.
That's crazy. You heard what he said? He said, man, I ain't finna keep going. I guess he talking about he want to change his life. But now you caught up in the RICO. Y'all out here gangbanging and shooting and killing motherfuckers. Like, y'all doing way too much. You know what I'm saying? Allegedly, that's what they saying. Like, you be proactive instead of reactive. Change your life first. You know what I'm saying? I ain't saying you got to stop doing everything you do, but cut out the crazy shit. But they've been investigating these niggas so long, you know what I mean? Won't know they was done for. You know what I'm saying? They was doomed, but Thugger is right next to this dude in the courthouse. Well, he ain't right next. He's 2 people down from him. Well, like 3 people down. So y'all gonna see Thugger in a minute.
Yo.
Oh, hold on, let me get the phone. I'm finna get what's the phone on? I think it's finna hang up too much. Go ahead. Yeah.
Yo, my boy.
What's up, bro?
Holla them folk, baby. Them now.
I'm already on there right now. I just talked to him. My boss said they gonna call back when they wake up. But he just told me.
Alright.
You good?
Yeah, G.
What the hell they talking about?
They say I shot and killed somebody. Then they say gang charges and initiated to get ranked. Like I'm trying to do the shit for rank.
You have 1 minute left.
That shit sounds so damn goofy, man.
Man, what? But you know how that shit.
I'm already on that shit though. I'm finna be on bro ad though, but it more definitely go though. Shit, then wait till wake up.
Alright. Then I'm calling.
Alright, then love you.
Love you too. I love you.
Yeah.
The phone finna.
I don't know, I ain't need to.
I'm finna call you right now.
Oh, okay.
Alright.
The caller has hung up.
Okay. Your Honor, we'll move on to call 3.
This is crazy. These niggas got calls on calls, bro. He's still telling the other nigga, they say, stop saying that shit. Stop talking about it.
An incarcerated individual at Fulton County Jail. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number.
Thank you for using Securus. You may start the conversation.
Hey, man, appreciate everybody who in here, man. Please do me one favor, man. That's all I ask, one favor only. Please, if you haven't already, please smash that like button, man. It's your player partner IQ. It's your first time being here. Welcome. You know what I'm saying? It's Snow Gang or No Gang. You hear me right? We right here. Look, there go with Thugger next to this nigga in the with the blonde dreads to the left. On the defense side, you will see Thug. He next to the this bald head black dude right here. But yeah, this right now. This is live. This live streaming right now. You know what I mean?
Now.
Hey. You hear me?
What up, live feed? Yeah, Thugger right there to the left.
I hear you. Yeah, can you hear me?
Call my dad
You will
right
see
quick.
him when the camera back up.
Man, this shit lame in here, man. Fuck.
Yeah, Rice Street.
Yeah.
Which number, man? 770 or
Yeah, call that one. Call that.
Hey man, shout out, free all the niggas at Rice Street too, man. Let me say that I ain't gonna pause it no more because I remember being in Rice Street when I used to live in Atlanta. I definitely did like all together probably like 8 months in Rice Street, 2 months here, 2 months. Rice Street is crazy. I'm talking about I was in the towers and I was in the old dorm. I know, nigga. You know what I'm saying? Like, free all the niggas in Rice Street, boy. Rice Street, Fulton County, Rice Street, fucked up, nigga. Dang. Free all the real niggas, man.
Hello? Yo, what? Hey.
Yeah.
What?
Yeah.
Where you at?
The shop.
You busy? You got somebody in the shop?
Yeah.
All right. Now I'm finna say go by the house right quick.
Who house?
You know what house?
Oh, okay, but what name? Say you gonna come down now?
Gee, get what they saying? They say, man, I shot and killed somebody. Then they say the gang charges. Then they say the reason I did it was to get ranking initiated or something.
So what is that?
Yeah, you know that cap. I ain't did none of that.
Hey, no cap. The nigga lawyer look like Aiden Ross. No cap. That look like Aiden Ross if he would have became a lawyer. Like the fake comb over there's crazy.
Yeah.
All right, I'm down here.
6745. Yeah.
Okay.
Yeah.
But I need you to go to the house though.
Free all the real niggas, man. Free all the real niggas.
And get that stuff.
From me, man?
Yes.
Huh?
Yes.
Okay.
So that my gun under the bed though.
What the fuck
you
did
can
he
leave
say?
that under there.
What the fuck did he say? My gun? Maybe he's not a felon. But he's saying, hold on. I didn't hear what I thought I heard. Did he just say my gun, y'all? Aiden Law.
Okay.
What the fuck did this nigga just say?
So that my gun under the bed though. You can leave that under there. Yeah.
So, Your Honor, at that point, after the court heard, Mr. Farley asked it sounds like another person that he had the called party call.
Niggas talking about
and instructs that
gun.
person that he needs to go to the house and get the stuff. And then he specifies my gun under the bed. So I want to relate that back to the bond motion. Here we are talking about covering up the cell phone and covering up the gun. That's exactly what happened based on those calls. And obviously that's relevant also going to the jail calls motion. And we'll keep going.
Just for the sake, you can leave that there.
My bad, Black Wall Street.
Okay, but it's, all right.
Right.
Hey, listen.
You hung up, man.
You know the one. You know the one.
Uh-huh.
Yeah, get him that.
Okay.
What, you finna hang up on me?
Huh?
You don't want to talk no more?
No, what are you talking about? I mean, I just said, okay, I got you. Like, what else you want me to say?
Damn. Well, that was abrupt. What the fuck? Damn, so yeah, it be doing this sometimes. They should come back in a couple minutes or right away. Ain't really no telling. I'm tripping, bro. Please smash that like button, y'all. Please smash the like button. We got 440. We in here watching Thug and them, and then at court right now. They doing a hearing. This is not even a trial. This is them trying to get all the evidence, make sure all the evidence is official that they got. You know what I mean? But They be doing this shit sometimes too. Let me speed it up, see if it's gonna. Okay, here we go. Hold on. And I ain't gonna stop it no more, y'all. Goddamn.
Yeah, what, Miles?
If you lift up the mattress, it's under the mattress.
You have 1 minute left.
I seen it.
Yeah, get him.
You want me to give the other one like back to him that's behind the bed?
Nah, hell nah.
Or just the 3, what you call it?
Yeah, get him the 3. The 3.
Yeah, okay. And that's it?
And the other that thing, bro, that I be riding with. You remember the one I gave you?
Okay.
You remember the one I gave?
Your Honor, the defendant just instructed the called party to give him the 3, not the one under the bed. I think from context clues that would suggest, or at least have enough probative value to suggest that there are 3 other items, perhaps guns. He also references not the one I've been riding around with. Again.
Yeah.
You keep that. But the other one,
You never gave it back.
I'm telling you, can keep it. It's under the thing.
Oh, so that's the one that's under the mattress?
Yeah, it should be 2 under there. At the
It's
end,
lying. That's what I'm trying to tell you.
go to the right side. It's always at the right. Unless they got it.
You can't call back in.
Yeah. Unless they got it, it's always at the right.
Oh. I didn't see that.
Thank you for using
So which one?
Securus. Goodbye.
Damn. I know his lawyer like, what the fuck? You didn't tell me.
And Your Honor, now this is the last call that Mr. Farley's contesting.
Okay.
This is a free call from
An incarcerated individual at Fulton County Jail. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number.
Thank you for using Securus. You may start the
Yeah,
conversation
that's
now.
him talking. That's why they got the camera on him.
Hello.
He just said I gotta wrap it up. I got 1 minute left. Shit, they got down. If you can take songs, what we gonna do to have? You know what I'm saying? But I'm gonna call you.
If I could do what now?
If you can take it up there to him, you feel what I'm saying? Before you go do that, like on your way to do that.
You go to watch English, I can't leave the house. I was gonna have her come here.
And Your Honor, this is the part that we believe is relevant on this part, which is that he asked the called party to take it up there to him on her way to go do hair. And Your Honor, we'll stop there. We know that the court's heard a lot of these. The court, we're welcome to play the rest of it if the court would like to hear it.
I'm good.
Okay. And so, at the court's pleasure, I do have argument on those calls that we heard.
All right, okay, well, go ahead, let's hear your argument.
Okay.
Start out with call number 1.
Your Honor, so what's important here, and this is I'll go first with the motion in limine, and then I'll reference it back to the bond hearing. As to the motion in limine, each of these calls is relevant when considered in context with the other calls. So call 1 is when the called party references the fact that basically people came to the house looking for something. Then in the following calls, it details Farley's attempts to hide the item that the officers came looking for. And I think Farley seems to even concede that the item that they were looking for is a phone, because he says, don't turn it on, go throw it away, essentially get rid of it. And he now contends that that's because he was having, outside relationships, but we don't know that, and the jury doesn't know that. That's a matter of interpretation. It's enough to be relevant, and he can argue at trial what he argued here. That's a perfectly acceptable argument, but nevertheless, it doesn't make it not relevant. I think that leads us into 2. It's just where he says all that, and he says it's in the hair box, and he says where to find it, and says not to turn it on. So I think that's enough to be relevant. Relevance is an extremely low bar, Your Honor, and that is enough to be relevant. And there's nothing prejudicial about it. He never says, don't turn the phone on because I'm cheating on you. He just says, don't turn the phone on. It doesn't go into any kind of extramarital affairs or anything like that. He's welcome to interpret that however he'd like to, as is the jury, but it's relevant. It's nevertheless relevant to show that he is, in the state's contention and based off the recording itself, clearly trying to hide something that they, quote unquote, came looking for. As to the third call, I think this is the one that essentially is why the other calls are all relevant and goes into this third call. In the third call, this is when Farley instructs the called party to give, quote unquote, what they wanted to Farley's father. And another caller then joins the call. Farley discusses the case, and then he instructs the third person added to the call to go to the house and get the stuff. Farley references a gun under his bed. Farley also tells the called party, you know the one, give him that. He repeatedly references what they wanted, and then he references giving all 3 items to his father. Farley instructs the called party to look under the mattress, explaining the one she can keep is under the mattress. That goes back to the gun. Farley also references the phrase, "is the one I be riding with," and he says that the item is all the way at the right unless they got it. So he's clearly giving instructions to an item. It would suggest from context clues that that is a gun. Call 2 obviously concerns the phone. We have suggestion from context clues that that's what it means. Finally, in the fourth call, Farley instructs the called party to take the item up there to him, that is to another location. Considered together, this shows that Farley made efforts to hide evidence or items for which law enforcement came to the house looking. The relevant standard, Your Honor, is very low. This is enough to be relevant evidence. It shows that Farley is trying to hide something, arguably a cell phone and a gun. That's what it suggests, at least to my listening of it, and I believe it could certainly suggest that to a jury. I also think his discussion of the case itself is relevant. Obviously, in the first call, the called party, suggests that he cooperate with law enforcement. I think that's all relevant. So first of all, Your Honor, we'd ask that this court deny Farley's motion in limine. As to the bond, it goes back to what I said before. For all the reasons that I stated previously, including that Farley clearly, as Mr. Menendez, we aren't saying he personally is owning a phone right now, but he clearly had access to a phone in the jail based on that photograph. Additionally, Your Honor, he's charged with murder. That is a very serious charge. He was charged with that before he even got these additional RICO charges and the charges in this indictment. Your Honor, and this goes back, back to point 1. He's charged with murder. That was a homicide involving a shooting. So I think the existence of a gun is going to be even more relevant to that. But back to the bond, Your Honor, this is extremely relevant information. The state never lied about the contents of the jail calls. The court just heard them. I think it's clear from the jail calls that Farley did try to hide a phone and a gun from the authorities, because he asked if they even referenced if the cops, if they didn't get it when they were there. That was even a reference in there. So I think, Your Honor, that this court properly denied Mr. Farley bond. My understanding is that this case is going to trial within the next 2 to 3 weeks. And so we'd ask that this court continue to deny him bond and to also deny his motion in limine. Thank you.
As for the motion in limine as it relates to the jail calls, the court does find that calls 1, 2, 3, and 4 are in fact probative and relevant, and especially in regards to the potential evidentiary value of what the state may introduce at trial and the conversations and context that may be relevant. Also related to the phone and the gun, there is some evidence to believe that this phone and gun tried to be attempted to be hidden or secreted from the authorities. I do believe, as Ms. Rosenwasser has indicated, that it would be relevant for the purposes of bond, and for that reason, I'm going to deny bond.
Thank you, Your Honor.
May we have a written order on the...
Yeah, if you prepare a suitable order on both those matters, please, now.
Yes, Your Honor.
You can show that to Mr. Menendez, and we'll prepare that.
Yes, Your Honor.
Just one note with regard to this evidence. You admitted it, but you admitted it against Mr. Farley. This doesn't resolve the 801D2E issues with regard to everybody else. So I want to make sure that, well, it's got 801D2E issues, we've got Bruton issues of his jail call comes in post-arrest with regard to everybody else in count one, and I do not want to acquiesce to that.
And Your Honor, we do have a separate 801D2E motion, so I think that could be addressed at another time.
They're gonna show them.
And that's correct. I just want to make sure that that with regard to these particular post-arrest statements of a co-defendant, we've got several substantive issues before they can come into trial, not just against him.
On behalf of Mr. Stillwell, I join in Mr. Harvey's.
Mr. Harvey and Mr. I would ask that you more or less, Mr. Harvey, that I can go ahead and have
I filed an 801D2E, and I think there are
motions adopted. You'll need to file some particular motion.
I did.
Not you.
Oh, I'm sorry. I'm sorry.
Yeah, the other strap hangers, Mr. Harvey, okay, that have adopted your motion need to particularize their own motions because it depends upon what it says to me as to whether or not it's admissible or not.
Right.
So, saying it's a proven issue, whatever, we need to identify the statement and give some particular type of discussion as to why, as to what the court can consider.
Oh, I have filed such motions, but not towards this
Well,
particular statement.
look, a lot of folks just particularize it, because a lot of times that's what usually happens. The court has to kind of look at each statement by itself as it relates to that particular defendant.
You're entirely correct. Let's, as far as it goes, however, your lordship. But let's flip that a little bit. We filed a motion saying, hey, look, what 801D2E potential statements or statements of co-defendants are you going to use? So that we file a motion in limine, but you got to tell us what you're going to use, like this one. So we can't particularize this whole mass of statements.
Ms. Rosenwasser, you're going to need to kind of parse out and do a little homework, whatever it is you decide to sit down and talk in this decision, because it will affect your opponent's opportunities to file
Your Honor, as we stated in our motion, we would just ask that they let us know what they're objecting to so we can respond to it.
Okay, Mr. Harvey's saying that you need to identify what statements you're going to, like for example, you're going to introduce statements against, involving defendant A. You need to go ahead and let them know you're going to do that. Why is that important? Because if defendant C says, well, that implicates me, then I need to be able to respond to it.
Your Honor, we provide all the statements we have in discovery. I think generally because it's a RICO, everything's going to apply to everyone. So if they could just object, it's going to be a lot easier for me to be able to prepare a response because generally our position is that all the co-conspirator statements, they are going to be admissible against everyone. So that's
yeah, given the type of case, but to the extent that you can, and it will affect because then I would certainly advise you.
A blanket statement that every statement everybody ever made since 2013 is a co-conspirator statement is blatantly overbroad. For example, this post-arrest statement from jail telling someone else to do allegedly something, and I don't know how he's going to explain it, but if that comes in, that's not a co-conspirator statement. I don't believe and will argue that, but we need to have it identified. Everybody has talked to everybody for the 8 years.
Well, see, Mr. Harvey, that's part of the state's, I guess, with the RICO statute and its applicability, that's one of the most powerful aspects of the statute.
Bingo, but it doesn't trump the 801D2E exclusion. It's got to show it's in the course of, in furtherance of the alleged conspiracy. So there are more hurdles than just saying, yo, it's a conspiracy, everything everybody says comes in.
And,
Even Mr. Botts knows that.
Your Honor, we have a full motion on that.
Stop saying CLEs. I mean,
Yeah, I guess.
it's along with you, so that may be a problem. I'm working on it.
Wait,
And Your Honor, I would just like to say on behalf of Mr. Stillwell that we do believe that the ball is in the state's court, and they're the ones that decided to indict this case this way. If they want to try Mr. Stillwell by himself, all these problems will be solved, but they have decided to put 28 people together, and it's very difficult to determine what statements by the other 27 people will be attempted. They'll attempt to implicate Mr. Stillwell with, and I think I speak for probably the rest of the defendants in that sentiment as well.
Okay, one second.
And you're on behalf of Mr.
I don't know why. Is it lagging a little bit? I feel like it's lagging a little.
Myrick, I would join in on what Mr. Shaw said. Mr. Shaw said.
I think Mr. Harvey said, unless you opted out, I'm going to assume it is that it'll apply to the rest of you, okay?
Yes,
All right, bless you.
Thank you, Judge.
All right.
we have Mr. Floyd here, Your Honor, for the murders.
I see him. Okay, all right. So, but to the aspect of that, Ms. Rosenwasser, you will have to kind of distinguish out.
Hey, please, y'all, please hit that like button. Hit that, please smash that like button. Please, that's all I ask, man. I appreciate everybody in here. If it's your first time, man, I go by the name of IQ Shaheed. You may have seen me somewhere. I've been lurking around on the internet for a while now, but this is my motherfucking channel and shit. We over here just watching this shit. You know what I'm gonna play it, but you know what I was saying? Thug and they don't want that nigga conversations to be used to get. He said, "Nah, nigga, don't put that on me." That's that man talking to his girl. He ain't saying nothing about shit. You know what I'm saying? I appreciate. Shout out DA Mark Mizzle. Oh, that's Mac Mizzle. What up, my nigga? I can't really see. I'm trying to look at the chat, but yeah, Thug said, "Don't put that shit." But I mean, that's how they. All y'all is co-defendants, really. You know what I'm saying? But let's see what the judge got to say. This live right
or
now.
Those particular statements. I would tend to agree with Mr. Harvey about that. You're going to have to distinguish the 801 D or E issues, okay?
Yes, Your Honor, I'll communicate that request to trial team and get that information to everyone as soon as I can.
Yeah. So I mean, it'll just make things a lot easier.
Absolutely, Your Honor.
Okay. All right. And you'll prepare an order denying that the issues as it relates to the motions in limine to the jail calls as well as to the bond, correct?
Yes, Your Honor.
Okay, wonderful. All right, okay. Mr. Floyd, good to see you, sir.
Yes, Your Honor, good to see you.
Okay, we have an amended special in General Demurrer 1, this relates to Mr. Farley, to dismiss count 1. There's an amended special in General Demurrer's 2, overt action jurisdiction. 3 pertains to overt acts and insufficient specificity of vague terms. 4 is unindicted co-conspirators. 5 is insufficient nexus. 6 is distinguishing between overt and predicate acts. 7 is duplicative counts. And then related to that would be an amended motion to sever, an amended motion to sever. And then the amended motion to sever his trial.
There's also one to dismiss the RICO count.
Yeah.
Ready on that?
Yes, to dismiss the RICO count. Yes.
Huh?
Is that the
constitutionality?
The constitutionality of it. Yes. If you could deal with those, sir, that would be wonderful. Okay. Mr. Menendez, do you wish to have any further argument on, or do you want to stand on your brief and I can let Mr. Floyd respond, or?
I want a little bit of argument, Your Honor.
Okay, all right, go right ahead.
Thank you, Judge.
Go ahead, sir.
So the first one, Your Honor, is a general demurrer. And so as the court knows, a defendant can generally demurrer if they could admit the facts in the indictment but not be guilty of the crime charged. But the way that the state has uniquely indicted this case leaves it open to an interpretation where Mr. Farley would not be guilty of count one because they won't have satisfied the element of having a pattern of racketeering, which is at least 2 acts of racketeering. So, Your Honor, the way this all really gets started is the state has put the indictment in 3 parts. They have part 1 where they talk about the conspiracy. And what's interesting here, Your Honor, is they list, and I don't know if Your Honor has the indictment.
I do, sir.
You do? Okay. They list out in part 1, they list these bullet points where they essentially list in all the possible ways that you can commit racketeering activity. But, Your Honor, what's very interesting is if you look at the last 2 sentences of that paragraph, part 1, it says, in furtherance of the conspiracy, the defendants engaged in the activities enumerated herein. But it does not say what they mean by enumerated herein. And in Black's Law Dictionary, it even says that the word herein is inherently ambiguous. It can mean anything here in this document. And Your Honor, they later in part 3, after describing the enterprise in part 2, they part 3 say acts in furtherance of the conspiracy. So the interpretation that I submit to the court is that when they say in furtherance of the conspiracy, the defendants engaged in the activities enumerated herein, under one general Demurrer interpretation, which of course is not the way that the state intended to write it, but it's a way that they left it open to interpretation, that herein means the acts in part 3. Because the sentence right after that says the objectives of the conspiracy included but were not limited to, and then it has a colon, and we can assume that the colon refers to the bullet points. But that way we can interpret that the bullet points are there only to articulate the objectives of the conspiracy, not as any predicate acts or acts of racketeering. So when they say herein, they could be referring to just part 3. And Your Honor, in the 1 through however many it is, 1 through 91 overt acts.
That's Mr. Farley. They talking about the light-skinned dude right here that the Aiden Ross / Joe Proctor lookalike is defending. That's the dude who's on the phone calls and shit. That's who they on right now.
Mr. Farley is only alleged to be part of a few of those, numbered 95, 103, 110, 120, 132, 141, 173, and 176. And then also very interesting, Your Honor, that first paragraph of part 3, it says, in furtherance of the conspiracy and to the effect its objectives and purposes, the defendants committed and caused to be committed, among others, the following overt acts, certain of which constitute acts of racketeering activity. So they've left open this ambiguity that of these 1 through 191 things, they're overt acts, all of them, but certain of them are acts of racketeering. So then, Your Honor, under my interpretation as a general Demurrer, you can look at each one of those acts and see that only 2 of them actually articulate criminal behavior. Because 95 talks about lyrics of a video that he's not even rapping in. 103 talks about a video that he appears in, not criminal activity. 110, again, talks about a video with some lyrics. 120 talks about him posing on a social media with clothing that has the word slime on it. Again, not criminal, not an act of racketeering. 132, engaging in a conversation. Again, Judge, that's not an act of racketeering activity to engage in a conversation, although that's the one where Mr. Williams is alleged to have made some kind of comment. 141, they talk about him having a tattoo that says ESPN, every slime plays nasty, or Rock Crew, raised on Cleveland. Again, Your Honor, having tattoos is not an act of racketeering. 173 and 176, though, Your Honor, are where they do accuse Mr. Farley of murdering Mr. Drinks. But now we're left with this general Demurrer. Certain acts are racketeering of this list, so let's interpret them as literally only the ones that say acts of racketeering, which one of them is murder, 173, 176. So if we interpret herein that way, and certain of which in the way I've said, we're left with just 173 and 176. But Your Honor, clearly those then allege the same exact thing. And I know the state's going to get up here and say, well, they're not the same exact thing because they satisfy different elements. But, Your Honor, they, in their manner, which they didn't have to articulate, they say that the defendants caused the death of Shamel Drinks, an associate of a rival gang. So even in that predicate act that's not gang activity, they talk about it being gang activity, saying that it was an associate of a rival gang and that they shot him as an act of racketeering activity. And then again, we have the same murder of the same person on the same time as the same alleged supposed gang, and it's worded the same, Judge. It's slightly different, but in both cases, they're talking about gang activity and a murder. And so that's not a pattern. You can't say that those two acts of racketeering activity constitute a pattern because they're the same act. They're going to say, well, one is the act as part of a gang and one is the act itself. But when they articulate the act itself, they say an associate of a rival gang. So they're saying there's gang activity even in that count itself. So they've just messed up here, Judge. They've left open an ambiguity to a general demurrer where I have found an interpretation that Mr. Farley in this indictment is only being accused of one act of racketeering activity. And Your Honor will see that the definition of racketeering of conspiracy to commit racketeering activity is a pattern, and a pattern is defined as two or more acts, whereas they've only, under my interpretation, accused Mr. Farley of one act of racketeering, which can't withstand a general demurrer, and so that's why it should be dismissed as a general demurrer for count one. And Your Honor, my relevant definitions are just, OCGA for the record 16-4-4, which talks about the pattern. OCGA 16-4-3, again, defines that there needs to be at least two acts of racketeering to constitute a pattern. I cite to Black's Law Dictionary where they concede the inherent ambiguity of the word herein. And then I cite to Meeks v. State and Johnson v. State as it talks about demurrers, Your Honor. So that's basically the argument of count one, is that there is an interpretation that I've just articulated where it leaves on.
Hey, one in the chat if this is a good lawyer. Two in the chat if this lawyer is trash. I think he might be good. He's very well spoken. I ain't gonna lie. He just young. You know what I'm saying? But one in the chat if he the shit. Two in the chat if he is some shit.
173 and 176, and that those are the same exact thing, even the murder, because it's alleged as gang activity in its manner, and that that leaves us with just one act, the alleged murder of Mr. Shamel Drinks as part of gang activity, and that's not a pattern, Your Honor, that's just one.
What up, Mo Dub?
All right, sir. Anything else?
No, Your Honor, I can answer. I know it's like a lot, but I can answer any questions that the court has about that.
No, I'm good. I'm good. Thank you, Ms. Menez. All right.
Everybody fucking with him
Thank you,
ones.
Your
I'm
Honor.
saying a lot
All
of
right, go ahead,
ones.
Mr.
He well spoken.
Two versions
He's sharp.
of this argument. The short one is wrong, 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 and wrong. The longer one is slightly more detailed.
Let's go with the longer one.
I'll go with the longer one.
Because it might get reviewed at some point.
I understand.
All right, sir. Thank you.
This argument has nothing to do with the text of the statute. And it has nothing to do with the governing legal standards. There is no, I have found an interpretation standard, and there is no standard applicable to general demurrers that endorses or indulges strained or artificial interpretations. General demurrers are not favored, and they are not construed in favor of the defendant. That's the starting point. So that the foundation is wrong. Specifically turning to RICO, it would behoove Mr. Farley to read the indictment as carefully and the statute, to read the statute as carefully as he reads the indictment. First, 1614.4c1 is the conspiracy provision. It does not use the term racketeering activity. It does not use the term pattern of racketeering activity. Okay? Mr. Menez is absolutely dead wrong when he says a pattern is an element of a conspiracy violation. The law is precisely to the opposite, and we cited the law in our brief. It is absolutely clear that a substantive violation is not a prerequisite to a conspiracy violation. If it was, the conspiracy violation would collapse into the substantive violation. It would become meaningless, and that would violate the most fundamental rule of statutory construction, which is the court does not read so much as a word, much less an entire subpart of the statute, to have no meaning whatsoever. Okay. The fundamental component, of a substantive violation is a pattern of racketeering activity. That's an A violation, that's a B violation. That is not what the state alleged. The state alleged a C violation. The C violation requires an overt act in furtherance of the conspiracy. It does not require a pattern of racketeering activity. Point one. Point two, he argues that overt acts must be acts of racketeering activity. No, same mistake. There is no reference to acts of racketeering activity in C. The case law is clear that acts of racketeering activity are not what are required. And as a foreshadowing to some of the other arguments that are going to be made, there are overt acts, 191 overt acts alleged. A subset of those, it's about 70, within give or take a couple, are acts of racketeering activity. They fall within the definition. Every single time the state alleges an overt act that is also an act of racketeering activity, it has said so. It has said an overt act that is also an act of racketeering activity, and it has said the exact incorporating provision from RICO that incorporates that underlying offense. Right? So we have drawn that distinction, but the point is both are good enough. And the first fundamental component of Mr. Farley's argument is we have to allege a pattern. That is wrong. The second fundamental argument is any overt acts we allege must be acts of racketeering activity. Equally wrong. The third argument that he alleges is that, or that he asserts, is that there has to be an overt act, he says consisting of a pattern, we've already taken care of that one, but that there has to be an overt act by Mr. Farley. Again, equally wrong. Overt act can be by any conspirator. That's exactly what the statute says. And that any conspirator commit an overt act in furtherance of the conspiracy. Pasha v. State, which we've cited, makes this point perfectly clear. So does Whaley v. State, which we've also cited. As Whaley said, it has the basic principle of conspiracy, which we've talked about in various motions during the course of this, but Pasha says that each actor in a conspiracy is responsible for the overt actions undertaken by all the other co-conspirators in furtherance of the conspiracy. Those 191 overt acts, those are all Mr. Farley's in a conspiracy case. Okay? Whaley says the same thing. A conspirator is responsible for his own racketeering activity and that of his co-conspirators. Whaley went on to say, this means that everything said, written, or done by any of the conspirators in execution or furtherance of the common purpose is deemed to have been said, done, or written by each of them. So this parsing that Mr. Farley's trying to engage into fails at its inception. He got the wrong requirement when he says pattern. He's got the wrong requirement when he says racketeering activity. And he's got the wrong requirement when he says it all has to be engaged in by Mr. Farley. This case would survive General Demurrer if you wiped out every single overt act specifically alleged to have been committed by Mr. Farley. It would still survive General Demurrer because he could not admit the allegations and still be innocent. For that reason, the General Demurrer should be overruled.
Your Honor,
What about the issue of the special Demurrer?
Well, he hasn't, at least here, asserted any argument. He began by saying this is a General Demurrer, and he hasn't asserted an argument relative to the special Demurrer. If he had, it wouldn't work for the reason that the indictment is very detailed. You know, one of the things that sort of becomes a hallmark of cases like this is that one defendant gets up and complains about how long the indictment is, and the next defendant gets up and complains that the indictment doesn't have enough detail about him. But, we've set forth the standard for special demurrer.
Doug is behind the prosecutor. Y'all can't see him. He just was on camera a few minutes ago, but it'll pan over. He got a gray suit on.
In the brief, Sanders v. State, a 2022 Supreme Court decision says that, and it basically says, while Sanders may desire greater detail about how the conspiracy resulted in Singletary's death, it is not required that the indictment give every detail of the crime. A pause, because I'm not quoting anymore. That is particularly true in a conspiracy case where the state is not required to allege the details of overts and where the overts need not be crimes themselves. They can actually be lawful acts as long as they promote the objective of the conspiracy. Here we have many that are unlawful and constitute racketeering activity. We have others that are unlawful but are not within the definition of racketeering activity. And then we have a third category that are just overts. All of those can be found within the 191. But as Sanders went on to say, instead, the additional detail desired by Sanders may be supplemented by the pretrial discovery he receives and any investigation counsel conducts. Every detail need not be in it. They have to be sufficient to assert a plea of former jeopardy and sufficient to be able to defend. The Supreme Court dealt with this in Kimbrough. This is an argument that's coming in a couple more motions about the Nexus argument. The Supreme Court basically said, you don't need to plead everything. We don't need pages and pages. We're not requiring pages and pages. You just have to have something. We have a lot more than that something here. We have dates, names, places, names of victims. It is set forth in a chronological order. Where there are multiple actors involved in the overt act, we have alleged who those people are by name. That is more than sufficient details to survive a special demurrer, Your Honor.
Okay, all right. I'll pause just a second, and I'll let you come back up and argue the motion to sever the counts, and then his motion to sever his defendant, and then constitutionality. Okay.
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 You want to come back to the other demurrers?
Yeah. Just unless you want to address them right now.
Your Honor, I'm at your pleasure.
Your Honor, that was only Demurrer 1. I titled it amended special in general because that's my original consolidated motions, but that was amended as just a general Demurrer, and I didn't even argue 2 through 7. But I do want to address his arguments about this general.
And Judge, just one moment. We have our own demurrers, but these counts relate to Mr. Nichols, Mr. Stillwell, as well, and the overt act. So,
hey man, I need that free thugger in the chat, man, right now, man. Free thugger in the motherfucking chat, man. Free slack, man. Damn, thug. This nigga such a star. He's still putting on the show. Free thugger.
Adopt, at least insofar as an argument is concerned.
Free Jeff.
Some of them relate to specifically to Mr. Farley, but to the content of the indictment itself. I would reserve my right to respectfully disagree with Mr. Floyd in what he has said, because they have pled, by the way, a pattern of racketeering activity. And if that ain't what they mean, then they shouldn't have pled it, number one. Number two, conspiracy is a specific intent crime. You have to specifically intend to commit the underlying predicate felony, which includes a pattern of racketeering activity. You have to have that specific intent. So I want to adopt and reserve, because some of these things relate specifically to Mr. Farley.
Thank you, Mr. Harvey.
On behalf of Mr. Stillwell, I too would like to adopt and echo the sentiments of Mr. Harvey and Mr. Nichols.
Your Honor, I don't think you're inviting argument on those motions separately, but I can address it if you want. But I'll just point out that if we have in fact pled a pattern, that's the end of that motion.
And Your Honor, it's just not.
No.
Yeah.
You pled the fact that the conspiracy was they did unlawfully conspire to acquire and maintain directly and indirectly through a pattern of racketeering activity. That's what the indictment says. You've pled it. And if it doesn't contain that, you're wrong about saying we don't need
I like
to put
him.
it in.
Hey, one in the chat. If he a beast, I like him because he ain't scared to speak up, nigga. He done spoke up a few times. Like, no, fuck all that. Look, this what I'm saying though. You see what I'm saying? One in the chat if he the shit. Two if he trash. We gotta find out who this nigga is. Old head. Look.
Yes, Your Honor.
Mr. Floyd, you want to, since they
He said keep
started
that shit
to have multiple streams of arguments, you want to respond to that?
I'll do it however you want.
Okay, sir, go ahead and respond to that, Mr. Harvey's assertion.
Okay. We're being quoted out of context. The objective of the conspiracy entails the commission of a pattern of racketeering activity. Alleging that a pattern of racketeering activity was actually committed is not an element of a RICO conspiracy. The offense is the agreement as opposed to the pattern. That's why there is not a reference to a pattern of racketeering activity in C1. Mr. Harvey's just mistaken on that point. And the specific intent, there is no separate specific intent requirement for a RICO conspiracy other than the agreement itself. That's it.
He's a defense
It's not
lawyer,
an
that guy.
underlying second.
Hey man, appreciate y'all pulling up, man. You should play a partner IQ if you don't know, man. IQ Shaheed, man. You know what I'm saying? Home of that underground shit, man. All the underground music, you know. This what we the culture, you feel me? Please smash that like button. That's all I ask, man. This is live right now. Y'all seeing Jeffrey Freak Thugger, man. Let's get back into it.
Layer of intent to commit a predicate act. It's just not a requirement.
Conspiracy is definitionally a specific intent crime because you have to have the specific intent to agree to commit the underlying alleged act. It is not a general intent crime. Conspiracy to commit a crime is a specific intent crime. So, and I know I'm a little bit out of order, and Mr. Floyd is way smarter than I will be. But I just want to reserve my right to argue, to maintain the argument and adopt his argument.
And I'm fine if he reserves, Your Honor. I'd like the opportunity to respond in full, too. Because this is not part of Mr. Menendez's motion.
You're correct.
And Your Honor, Mr. Floyd, you want to go ahead and finish his, because he's got like 7 of them. He's got this. 1 is dismiss count 1. 2 is overt action jurisdiction. 3 is overt action insufficient specificity in vague terms. 4 is unindicted co-conspirators. 5 is insufficient nexus. 6 is distinguished between overt action predicate acts.
It was live. It must have just went off.
And 7 is duplicative counts.
And the way we've allocated responsibility for these, Your Honor, 1 through 6 are mine, as well as severance and constitutionality. And I'm at the court's pleasure. If we want to go through them all right now, I'm ready.
Yeah, let me let you finish those, and then I'll let him address if he's got anything more. Because
let my young nigga finish, man.
So, Mr. Mendez, let him finish, okay?
Well, Your Honor, I never made my arguments about 2 through 6 yet.
I thought you did.
No, Judge, that was all just number 1. And I want to address some of his misstatements about number 1 as well just now.
Okay.
Before the court rules. So Mr. Harvey is right about that specific intent, first of all. But let's back up.
Okay, but let's not get too far down the weeds.
No, I know, Your Honor.
All right. In specific intent is they're inchoate crimes, okay?
Right.
All right, so, yes, you do have to prove, there are specific intent crimes, but that's an issue of proof.
Right, Judge.
Okay.
And so to back up, though, to several things that were wrong about what he said. So look, he says there is no, I have found an interpretation about general demurrers, when that's exactly what a general demurrer is. If you can interpret the indictment in a way that the person has not committed a crime, meaning they have not committed all the essential elements of the count, then that's what a general demurrer is. So that's just a bit of gaslighting, a bit of, oh, if I just say it confidently and say it in a cool way, then I'm right. No, he's not. That's exactly what a general demurrer is. When there's an interpretation of the indictment that the person's not guilty and has not satisfied all the elements, it has to be dismissed. And that's exactly the interpretation that I've presented to the court. And then Mr. Floyd tries to get up here and misread the statute talking about, oh, we did it under subsection C. Yeah, I know that. That's why I filed the motion. Subsection C, Your Honor, says it shall be unlawful for any person to conspire or endeavor to violate any of the provisions of subsection A or B. A or B. You need at least one of them, and he's going to come up here and say, oh, we only needed C. Well, you need at least A or B in both of the ways that someone can commit C. And then they have these two ways. A person violates this subsection C when either one of these two happen. He or she, together with one or more person, conspires to violate any of the provisions of subsection A or B. So you do have to violate subsection A or B to violate subsection C. So how can he come up here and say that? Or let's look at the other way then. Number 2, subsection C2. He or she endeavors to violate any of the provisions of subsection A or B of this code section. And both A and B have the word pattern in it, and pattern is defined in the statute as 2 or more, and they've only alleged 1 against Mr. Farley. And so the way this indictment can be interpreted is dismissed by general demurrer. And just because they can present the court with their interpretation, that's not enough. They need an indictment that is perfect in form within its 4 corners and that someone can't admit the facts to under any interpretation of innocence. And they haven't done that here, Judge. They've alleged it the way they alleged it, and that's on them. And as it pertains to just Mr. Farley, because only 2 of those acts are actual acts of racketeering alleged, and they're both the same act, that's why it's dismissed by a general demurrer. And that's why I put it as number 1, because we shouldn't have to argue 2 through 6 anymore, because number 1 is just, as far as it pertains to Mr. Farley, dismissed by a general demurrer by the exact way that Mr. Floyd said not to interpret it. Because yes, there's an interpretation where he's only being accused of 1 act of racketeering, and yes, under subsection C, you need a pattern. He tried to come up here and say you don't need a pattern in subsection C, and that's just not true, because I just read the whole code section to this court, Your Honor. And in both ways you can commit C, it says either A or B has to be violated, and in both A and B, the word pattern of racketeering activity is included, Your Honor. So that's why, for Mr. Farley, this general demurrer should be granted. And so I can go on to the rest of my demurrers, but I'll wait the court's ruling on the first one to see if we even need to go there.
All right, go ahead.
4 cases, Your Honor. United States v. Brown, 11th Circuit, 2007. Defendant may violate RICO's conspiracy provision even if he did not commit a substantive violation of RICO. United States v. Alonzo, 11th Circuit, 1984. Defendant may be guilty of a RICO conspiracy violation even if he did not commit the substantive acts that would constitute violations of subsections A or B. United States v. Salinas, Supreme Court of the United States. Defendant can be guilty of violating RICO conspiracy without violating a substantive provision. Cotman versus State, one of the APS cases, defendant was found guilty of RICO conspiracy without proof of a substantive violation of A or B.
And Your Honor, can is different than shall. Yeah, you can, but not with this one because of the way they wrote it.
Okay. I'm going to deny your motion, Mr. Benitez, as it pertains to dismissal of count 1. You have any other further argument on overt acts?
Yes, Judge.
All right, let's go.
My second demurrer is a special demurrer. Oh, no, I'm sorry, Your Honor. The second one has to do with a jurisdictional argument. Because, Your Honor, if you follow some of the same things I articulated first about the indictment, you see that there are, in Part 3, certain overt acts that I believe under general demurrer need to be dismissed against Mr. Farley because they don't allege where exactly it was committed. They talk about released on social media. They say appear in a YouTube video. Well, Your Honor, YouTube is not a place. They didn't say that anyone in Georgia, because the Georgia RICO statute needs acts in Georgia. So all these social media ones that they have about Mr. Farley, for example, number 95, it says he appeared in a video released on social media. They didn't say that the video was made in Georgia. They didn't say that anyone in Georgia saw it. They just said that it was released on social media. And same thing with 103, Your Honor. They say that he appeared in a YouTube video. They don't say a YouTube video in Georgia. They don't say that anyone in Georgia saw the video. And so, Your Honor, that's the same for 110, 120, 132, and 141. 132 is a little different. It talks about engaging the conversation. But again, Your Honor, they say that Mr. Farley engaged in a conversation, which, by the way, is actually his clothing Instagram account as part of like a massive group message, and he doesn't even respond to it. So I don't know how that's engaging in a conversation with Mr. Williams. That's not how I define engaging in a conversation, but I'll move on from that, Judge. Regardless, it doesn't say where that conversation took place. Instagram is not a place. Instagram is not in Georgia. So they should have alleged that that these people were in Georgia when they engaged in this conversation. Again, Your Honor, number 141, a photo released on social media displaying tattoos. Does not say those tattoos were seen on social media by anyone in Georgia, or that he's ever been in Georgia, or that those tattoos were made in Georgia. And we don't get to consider everything we know. For General Demurrer, we look at just the four corners of the indictment. So, Your Honor, going to my authority and argument part, there's federal case law about this, Your Honor. It's Butte Mining, which is 76 F3D 287 291. That's out of the 9th Circuit.
How about the 11th Circuit or United States Supreme Court? That would be more persuasive to me.
Well, Your Honor, yeah, I'm using the interpretation of the federal statute.
Georgia, though.
Right.
Do you have any 11th Circuit interpretation on that?
That's not been addressed by the 11th Circuit, Your Honor. This happened with a case about
Been
RICO.
addressed by our Supreme Court?
No, Your Honor. What I'm saying is that the Georgia statute exactly tracks the federal statute, and the federal statute's been interpreted to mean that those acts have to be in the jurisdiction of the court. Those are the cases I was going to bring up, where in Butte Mining and the Sonal Trinol, those acts were alleged possibly in foreign jurisdictions, and that basically what I've articulated from Part 3 also might have taken place outside the state of Georgia. So I don't think that needs the 11th Circuit. That's just, this is how federal RICO is interpreted, so why would we interpret Georgia RICO any different when it's tracked and written exactly the same way? And so, Your Honor, in those cases, the demurrers were granted because the 9th Circuit held that the defendant's conduct in the United States, by use of the mail and the wires, paying a fair price for the mining company, forming corporations, that those didn't actually refer to the fraud, and that the actual fraudulent acts took place entirely outside the United States. And so here, there's an open interpretation that these acts, putting something on YouTube, appearing on social media, engaging in conversation, those acts could have occurred outside of Georgia, and nothing specifically alleges them to have occurred inside Georgia. And so,
doesn't the state have to prove that anyways as to each count by indirect or direct evidence?
At trial, to meet their burden of overcoming the presumption of innocence, but he's also entitled to a perfect indictment within the four corners, regardless of looking at discovery or...
I don't think the indictment, the count requires that specifically that, because that's the state's burden of proof at trial.
Well, Roger,
it's implicit within each count that venue's got to be proven. It doesn't have to necessarily be pled.
And Your Honor, in those federal RICO cases, that wasn't enough to survive the General Demurrer because of the way it was pleaded in the indictment. Okay. And so that's what I'm alleging here. And so because those acts can have occurred outside the jurisdiction, they can't survive General Demurrer. So those...
But we don't know if they have occurred outside the jurisdiction, do we?
Right, Your Honor. We would have known that had they said appeared in a YouTube video seen by people in Georgia. It would be that simple, but they didn't do that. So that's why those overt acts, Your Honor, and there is case law about demurrers applying to actually individual overt acts as well, not just the entire conspiracy. And I have that, Your Honor, in my motion as well. That's Ralston v. Cox. They talked about
Said judge not going.
Okay, that seems to,
that's
seems to occur. I mean, you seem to be arguing overt action, jurisdiction, and insufficient specificity and vague terms. Is that what you're kind of?
That's the next one, Judge. I'm still on the second one, which is the jurisdictional argument about those overt acts. Because Ralston v. Cox, you can actually demur to the overt acts, because in that case, the lower court sustained the demur to counts 2 and 3 and to the overt act number 3 of count 1. So I included that just to say that this court, it has the authority to address demurs based on just the overt act. It doesn't have to be the entire count. So that's what I'm asking the court to do. Because the court has denied my previous demur, I'm asking the court to narrow down the indictment to take out these, what I believe are general demurrable things because of the jurisdiction argument. And so those overt acts, because they can be committed outside of Georgia, just don't survive general demurrer. And that's much different than, I understand what Your Honor is saying about they don't have to prove venue, like they don't have to say in the exact count 55, murder Schmel drinks in Georgia, but the entire indictment talks about, this is a Georgia conspiracy. But just like in Butte Mining and the Coca-Cola case and the Sunel Trail cases that I cited, in those cases, it was a federal United States conspiracy, but those, overt acts that were outside the jurisdiction possibly could not survive general demurrer, Your Honor. So that's what I'm asking here. It would have been simple to just say what exactly the overt act is doing, because in the other ones, like when you say murder Schmel drinks, we can assume that happened in Georgia because it says honor about and this is and that. But it doesn't say that the...
Man, we got 4K in the chat, man. Shout out to the whole chat, man. It's no gang, man. It's IQ. Look, man. Shit getting thick in here. All I ask, man, please hit that like button, gang. We can get back into
YouTube video was seen by anyone outside Georgia. That's the problem that's missing, Your Honor. And it doesn't allege that it was created in Georgia. The act they're alleging is appearing on social media. And so that's what I contend to this court, is that you can appear on social media outside the jurisdiction. And that would have easily been solved if they would have just wrote seen by people in Georgia. I think, it's like a tree falling in the forest type of thing. Like, you can allege that he appeared on it, but then you also have to allege that it was seen. Otherwise, it's not an overt act.
Thank you. Mr. Floyd?
Yes, briefly, Your Honor.
I am at a loss for this it has to be seen argument. I mean, Mr. Farley is basically coming up with every requirement you can possibly think of and throwing them out as though they're in the statute or they're in a case. They're not. The reference to the Cox case, Cox is a former Fifth Circuit case from 1941, 29 years before the federal statute was enacted, 39 years before the Georgia statute was enacted. Whatever else, and a civil case at that, whatever else it has to do with, it doesn't have anything to do with the Demurrer to Georgia RICO. Most of the cases he cites are civil cases, not criminal cases. Different standards of pleading. The indictment on page 12 alleges that the crime took place in Fulton County, Georgia. Just to begin with, it's right there. Second, the text of OCGA 1614.3 sub 5, which is the definition of racketeering activity, makes it abundantly clear that acts committed outside Georgia, and in fact outside the United States, can be acts of racketeering activity or overt acts for purposes of Georgia RICO. It incorporates 3 categories of conduct. The first category we don't have to spend a lot of time on because those are specific violations of Georgia law, right? And that's the overwhelming majority of what we're talking about here. Second, it incorporates the full definition, the entire definition of racketeering activity from federal RICO. So those are all federal offenses that can occur any place in the United States or any place in the extraterritorial jurisdiction of the United States. For example, one of those offenses is killing a United States citizen outside the territory of the United States because they're a United States citizen. So by its nature, it couldn't even happen within U.S. territory. It's still an act of racketeering activity, right? And then just in case there was any doubt, there's a category of 12 generic acts: murder, arson, kidnapping, obstruction of justice are a few examples that are in violation of federal law, the law of any state, or the law of any United States territory, punishable by more than 1 year in prison. So the intent of the General Assembly to incorporate such activity is very clear. We're not talking about things that happen outside the state of Georgia anyway. We didn't allege they happen outside the state of Georgia, but if they did, it wouldn't make a difference. On top of that, there's the Overton case, which we cited in our brief, which is not mentioned by Mr. Farley. Overton is a Georgia RICO conspiracy case out of Richmond County where a significant part of the racketeering activity that occurred in the state of South Carolina. Obviously, we all know Augusta's on the Savannah River. There was a kidnapping on the Georgia side. The victim, unfortunately, was transported across to the South Carolina side. He was locked in the trunk. The car was set on fire. He died. Okay. Act of kidnapping, Georgia. Act of murder, South Carolina. Both in the indictment, both supported the conviction. Both are specifically cited by the Georgia Court of Appeals in response to the sufficiency of the evidence challenge. Really, Mr. Farley is arguing what the probata has to be, not the allegata. He's talking, as you mentioned, he's talking about what we ultimately have to prove at trial to carry our burden. He's not talking really about what we have to allege. But the sense that there is some possibility that an act occurred outside the state of Georgia because the state did not specifically allege that it occurred inside the state of Georgia, I don't know how that has any impact at all in a conspiracy case where the state has alleged the conspiracy violation occurred here. And the argument that anything that happens outside the state is automatically excluded simply does not fit with the statutory text.
All right. As it pertains to
he just, you know, he don't give a you could just tell that prosecutor boy he lock a nigga up. He the type he want to put. You see how he just. I don't know how many cases he did, but you could tell this is like he been doing this. Like he just programmed in this fucking. He don't got no emotion. Change our life, man. You know what I'm saying? Change your life, man, and don't get into that shit, man. You see, you got people like this.
Special and General Murder, 2 overt acts in jurisdiction. This court will deny the defendant's motion. All right, Mr. Menendez, number 3, overt acts and insufficient specificity of vague terms.
Yes, Judge. This is a just special demurrer as to several parts of the indictment. You know, I'm referring again to Part 3. The only overt acts that Mr. Farley's alleged to be in out of 191, that's number 95, 103, 110, 120, 132, and 141. Those are the ones I'm talking about here. Your Honor, here, the court's actually pretty clear. I mean, the Sarajewski case, held that that indictment was deficient and that it lacked any description of what was alleged to be threatening communication. So here in this motion, Your Honor, I'm shifting our focus to these vague terms that they're putting in the indictment that Mr. Farley is entitled to have be more specific so that he can be prepared to defend himself at trial, because he is entitled to an indictment perfect in form within its four corners. And the key thing here, Your Honor, under Sarajewski is that it needs to be sufficient so that he can avail himself of a defense, to prepare himself for a defense. He's not given enough intelligence here about what he's even going to be fighting. So just like when Sarajewski dismissed that count for threatening communication or endeavor to impede, that's what I'm arguing here, Your Honor. There's also the Delaby case that didn't survive a special demurrer. That had the term intimidation being insufficiently specific. So, Your Honor, each of these overt acts, except for 173 and 176, do contain terms that are so vague that we can't possibly prepare our defense intelligently within the four corners of the indictment, Your Honor. And he can't be sufficiently apprised of what he's going to be prepared to meet at trial. 173 and 176, I do concede, okay, you know, those are specific enough. It talks about shooting a person with a gun. That shooting with a gun, that can't be committed in any other kind of way. But importantly, Your Honor, the Delaby court holds that the term intimidation was impermissibly vague because intimidation can be, committed in so many different ways. And again, Your Honor, despite its age, Ralston v. Cox is still good law. It's an example where the court
has the authority to demur specific overt acts of conspiracies, not just whole conspiracy. And so, Your Honor, now I want to go to each of these acts and the allegations and how they're vague. So number 95, again, appearing in a video released on social media, doesn't say what that means. What do you mean appear in a video? And just the proof of what I'm saying, Your Honor, is the way it's been talked about at different points during this case in the proffers. You know, appear in a video, appearing doing what? Saying what? Rapping, dancing, what? It's just, that doesn't say, like, appear in a video, Your Honor. It doesn't say anything about how that's furthering the objectives of anything or what that even means, Your Honor. Same thing with number 103, that he appeared in a YouTube video titled Mob Ties and that the defendants were flashing gang signs with lyrics. He doesn't say, does he even say these lyrics? Does he mouth them? Did he write them? Does he rap them? What? It doesn't say, Your Honor. It just says he appeared in a YouTube video and then says defendants were flashing gang signs with lyrics. Which defendants? It should have said which ones. It should have said what they mean by appear. Should have said what they mean by the lyrics. What is the significance of the lyrics and Tupac and Hit 'Em Up? Doesn't say. Just says he appeared in there. Same thing with 110, Your Honor, a YouTube video of a song of Mr. Wunny Lee saying vaguely and sufficiently that he appeared in it. You know, at first bond hearings, they tried to say
that was a good. If y'all missed that, what he said like Tupac hit him up, because in Tupac hit him up, he specifically was saying, you know, he's saying, nigga, what was that nigga? Was he saying anything? That was good. That was quick too. He dropped that joint in there real quick. That was good shit.
Like he was saying the lyrics, or he had something to do with the lyrics. And while I don't think those lyrics are probative or have anything to do with reality, even so, he's not alleged to have written them, rapped them, mouthed them. I want to know, he needs to know what appear in a YouTube video means, and then they just say some lyrics. And Your Honor, now number 120, a photo released on social media that he posed for a photo. What does that mean, posed for a photo? How is that the overt act? What about posing in a photo and that it was released on social media? What is that? What is an overt act about releasing something on social media? Again, doesn't say anybody saw it and doesn't say what they mean by posed. So then go to 132, that he engaged in a conversation. This one really needs to be defined, Your Honor. Engage in a conversation, that's vague. What do you mean engage? Talking and talking back? Having your account that maybe you don't even manage get a message from other people that you don't respond to?
I just made you moderate a live feed. You moderate.
That's what it is, but we need to look at it within the four corners, Your Honor. And so to say vaguely, oh, he engaged in a conversation and then say stuff that they allege Mr. Williams to have said, what is that? How do I defend against that? What does that even mean? Same for 141, Your Honor. Posing for a photo. I already made those arguments for Act 110. So, Judge, those are the ones. They're all impermissibly vague. They each contain at least one vague term that needs to be further defined because it's not defined enough, just like in Delaby and just like in Sarajewski, where those things were not sufficiently defined. Here, I would argue to the court, we have terms that are even more vague than the terms in those courts which didn't withstand a special demurrer. And I know the state's going to cite the case law that, oh, we just have to track the language of the statute, but that's only the first part. It's a two-part analysis. They have to track the language of the statute, but they still have to sufficiently appraise the defendant of what he's going to be defending himself from. And these vague terms rob us of the chance to do that, Your Honor, and so that's why those overt acts should be dismissed by a special demurrer, because they are impermissibly vague.
All right, thank you, sir. All right, Mr. Floyd?
Yes, Your Honor. First point is the state is not required to allege every overt act, and the state is not required to allege overt acts in great detail. That's the law. They are not separate counts. They are overt acts as part of an overarching count. And so the level of specificity which Mr. Farley is seeking is simply not required.
I can only say it strikes me.
What? I'm sorry, I had to pause. That nigga, that's the first time I heard him start stuttering. That's the first time I heard the prosecutor say, okay, hold on. I'm running. My bad, y'all. That just stuck out to me. I said, oh shit, this nigga fucking up. He was fluent. You just fluent. Okay, hold on.
I can only say it strikes me as feigned confusion here. As to each of these acts, the state has alleged the specific date. It has alleged everybody who's involved. It's not like he doesn't know what we're talking about. Okay? The individuals in almost every one of these acts that are referenced, other than Mr. Farley, are co-defendants. The idea that he is bewildered at what it means to appear in a video, to appear in a photograph, is simply an untenable argument. What does it mean to be released? Well, people talk about releasing videos, releasing movies, releasing all kind of TV shows, etc. all the time. Social media, not exactly a vague term. And numerous times we've mentioned the specific platform, like YouTube. A conversation, again, not real confusing, particularly since we've quoted language from the specific conversation. And he has the videos, he has the photos, he has the transcripts and recordings of the conversations. And so under the standards that we've cited before, including Sanders versus State, that is more than sufficient. We're not talking about something where Mr. Farley wasn't present, and we're not talking about something that Mr. Farley hasn't received in discovery. We're not talking about something that's some grand mystery about what's going on. I've never seen a case that said this is demurrable, and I don't think this is going to be the first one. If Your Honor has any questions, I'd be happy to address them.
No, I don't.
Very briefly about that, discovery has nothing to do with here. It's not feigned or not feigned. It's that you need to do legal analysis and you need to put everything out of our mind. Come on, Ada. They saw very clear about that. So it doesn't matter that I've seen the videos. He's entitled to indictment perfect and form within his four corners to sufficiently praise himself. So all that extra stuff is actually not part of the court's analysis. It needs to be restricted to the indictment itself only. So we are going to feign ignorance because we pretend for purposes of the error that we don't know anything else except for the indictment. That's what it means.
Your Honor, Sanders versus State, unanimous decision, Georgia Supreme Court, 2022. The additional detail desired by Sanders may be supplemented by the pretrial discovery he receives any investigation or counsel conducts.
All right. I'm going to deny your motion in regards to General Demurrer, Special and General Demurrer's 3 overt acts and insufficient specificity of vague terms. Let's move on to the issue involving unindicted co-conspirators, Mr. Menendez.
Okay, thank you, Judge. The last 3 are actually very short and straightforward. I can probably do all 3.
That'd be fine. Okay. Unindicted co-conspirators, insufficient nexus, and distinguishment between overt and predicate acts.
Yes, Judge. Those are the same arguments under Special Demurrer that he's entitled to an indictment, perfect in form, that within its 4 corners puts him on notice of what he's going to defend himself against. The way that fails in this regard is that they just say in the indictment that Mr. Farley and the other co-defendants, together with unindicted co-conspirators, did these things. Well, for the indictment to be perfect in substance and form within its 4 corners, they need to say who those unindicted co-conspirators are. So that is the substance of this motion, Your Honor, merely that it doesn't withstand a Special Demurrer because it includes these unindicted co-conspirators without telling us anything about them or who they are. So that's that one. Number 5, Your Honor, it's just an insufficient nexus because under Schiffels v. Kemper Financial Services, which again, yeah, it's a civil case, but that's something unique about RICO is that it does have a civil component and a criminal one. And there's no difference in how those are decided. There's a difference at trial of what their burden is, either preponderance or beyond reasonable doubt.
Hey,
But as far as
shout out to the motherfucking chat, man. Appreciate y'all. We got 6K motherfucking live viewers, man. This is a personal motherfucking record for me, man. I appreciate y'all. I think the previous record was, 4,300, man. Please smash that like if you want to kick it here. This the home of the hip hop, the culture, the crazy shit. We be on all type of shit, man. Hit that motherfucker subscribe, man. Free Thugger, baby. Thugger right there in the gray suit too. If y'all, he's sitting back in the seat. You see him behind the black dude? That's Thugger right there. But they trying to grill one of his, I guess, co-defendants. Yeah, that's his co-defendant, the guy the light-skinned kid right there. And but the lawyer fighting, man. You know what I'm saying? The motherfucking lawyer fighting, man. But let's get back to it. I'm gonna take a head off. My bad.
As Demurrers, there is no difference, and there is a civil application of RICO. And in that application, Schiffels v. Kemper Financial Services, they say that to allege a conspiracy to violate Georgia RICO, the state would have to plead that each defendant knowingly agreed to conduct the affairs of a particular enterprise, and that each conspirator agreed to the commission of the predicate acts, and that each defendant knew that those predicate acts were part of a pattern of racketeering. So how can I do that when I don't know who these supposed unindicted co-conspirators are? So, Your Honor, again, under Schiffels, it says conclusory allegations of conspiracy are not sufficient to allege a criminal act under OCGA 16-4-14 and 16-14-8. Rather, the state must allege facts from which one can infer each defendant's agreement to violate the laws the state contends constitute the racketeering activity. So, Your Honor, for those reasons, it can't survive a special demurrer to have an indictment that says, oh, together with unindicted co-conspirators, because then how are you on notice of how to defend yourself? How are you on notice about what attorney you want to hire, or whether you want to make a plea, when you don't know whether that specific intent is going to be satisfied? You don't know who these unindicted co-conspirators are. That's a pretty simple thing, Your Honor. I think that line, unindicted co-conspirators, either needs to be removed or needs to be re-indicted to tell us who those unindicted co-conspirators are. As far as the insufficient nexus, Your Honor, that's the one I was just talking about before that the allegations need to allege facts to infer that each defendant's agreement to violate the laws. That was actually, I was talking about the nexus, Judge, my bad. There, they don't allege that, Your Honor. So the nexus between the enterprise and the conspiracy is insufficient by this indictment. And then lastly, Your Honor, they say overt and predicate acts, the part that I referred to in count one, where they say that some of these, certain of which are acts of racketeering, that's again not acceptable under a special demurrer. They need to say which are the overt acts and which are the predicate acts. They can't just list them and then say certain of these are acts of racketeering. They need to say these are the acts of racketeering, these are the overt acts that aren't. Because otherwise, how do I know which one they mean is which? So those three, Judge. Insufficient nexus, that applies to the entire count one. But as far as the distinguishing between overt and predicate acts and unindicted co-conspirators, that's just something that also needs to be included, Your Honor.
All right, sir. Mr. Floyd?
Yes, Your Honor.
He fighting, man. I mean,
So we have
he doing his best.
unindicted co-conspirators, insufficient nexus, and distinguishment between overt and predicate acts.
Fuck it. You know what I'm
Yes,
saying?
sir.
At least he
And then
fighting.
we'll move on. I think there's, Mr. Menendez, you haven't dealt with duplicative counts.
Oh, Your Honor, I think Mr. Floyd said a different colleague is.
I'll handle that response, Your Honor.
Okay, all right, okay.
Okay.
All right.
So on number 4, Your Honor, unindicted co-conspirators, no case cited by Mr. Farley that says we're required to identify those, and kind of misses the fact that they are unindicted. And there's a problem with identifying individuals who are unindicted in an indictment because they don't have the ability to come in and demur or otherwise seek relief. Their reputation can be devastated, but they don't have standing to come in and do that. That is why it presents, I can't say it never happens, but that is why the state and also the federal government are very reluctant to do that. And you see things like unindicted co-conspirator A or unindicted co-conspirator 1 referred to in indictments because that person doesn't have a chance to come in and respond. They're not a party. There are some jurisdictions that suggest it may be unethical to do so. It's not a universal rule, it's a practice, but it makes sense. Second, we've identified all all unindicted co-conspirators who are known to us in discovery. We haven't held anything back on that. As far as insufficient nexus, the case is charged in the language of the statute, and it specifically references the nexus. And all nexus is a connection. There has to be some kind of relationship. Kimbrough is the controlling case on this, unanimous Georgia Supreme Court case written by Justice Peterson. And it basically says it doesn't take much and gives a number of examples. We have specifically alleged they conspired to associate together and with others for the common purposes of illegally obtaining money and property through a pattern of racketeering activity and conducting and participating in the enterprise through a pattern of racketeering activity. That's exactly what a nexus is. And that is more than sufficient under Kimbrough. We then go on to give specific examples of what was done, such as preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence. That money, weapons, and other property were obtained through acts of racketeering activity, including robbery, theft, and the unlawful sale and distribution of drugs. We also allege that persons who were involved in the conspiracy to participate in and conduct the enterprise obstructed law enforcement investigations and court proceedings through witness intimidation and attacks upon law enforcement officers. That's drawing the connection between the conduct and the enterprise. That is all that is required. Distinguishing between overt acts and predicate acts, we did. I mean, we did exactly what Mr. Farley claims we didn't do, and it's right in the indictment. It's a key dramatic moment when the screen went dead black on me just as I picked it up. Your Honor, I'll just start with Act 1, and I'll blessedly stop with Act 1 because there's 191 of them. But in that case, we talk about aggravated assault with a deadly weapon, a firearm against the person of Reginald Pettis. Go through the allegation. In violation of Georgia law pursuant to 16-521, which is an act of racketeering activity under OCGA 16-4-3 sub 5A little v, and an overt act in furtherance of the conspiracy. Where it is both, we say exactly that. We do it over 70 times. Where it is only an overt act, we do not make the reference to the underlying incorporating provision from RICO. An example of that is number 7, which involves Mr. Murphy. We consistently did that throughout the indictment. That's exactly what he's complaining of. The thing he says is missing is there.
Okay.
Oh, okay, whatever, man. I get it, man. He ain't really saying, he just reading.
That's all I have right now, Your Honor.
All right, sir.
Yeah, we got it.
In terms of...
we get it.
Tag along to the first part of that one, the unindicted co-conspirators, not the other ones.
Where you been at?
I do have a similarly situated motion with regard to the identity of unindicted co-conspirators.
Where this nigga been at?
And the indictment does say the defendant conspired to associate together and with others. Doesn't say who the others are, and we can argue this at a separate time. I have no problem with that, but I do want to say, in contradiction to what Mr. Floyd said, that we routinely file motions for the names and identities of unindicted co-conspirators. They may not be put in the indictment, but we routinely are provided with a list of unindicted co-conspirators because we all are entitled to know who we have conspired with, number one, and whose statements may or may not be able to be used against us under 801D2E. So I just want to tag in on that one.
All right, thank you, sir. All right, based upon the arguments and applicable case law. I'm going to deny defendants
Damn. He ain't showing no love.
unindicted. Amended Special and General Demurrers 4 unindicted co-conspirators. I'm going to deny insufficient nexus. That's General Demurrers, Special Demurrers 5. I'm going to deny distinguishment between overt and predicate acts. And I think that gets us to the duplicative counts in terms of general and special demurrers, as well as the motion to sever counts, motion to sever the trial of defendant, motion to declare the Georgia gang statute and corresponding rule of evidence 418 unconstitutional, and the Georgia RICO statute unconstitutional.
And Your Honor, I was wondering, I know we're getting late into the day. I'm going to be here all day, all week. So if the court would like to
2 shows daily.
Here's the one I'm doing tomorrow, and just hear Mr. Floyd's. That's as amenable to me or the court.
Okay, Mr. Floyd, what else are you arguing, sir?
I've got severance and constitutionality, Your Honor.
All right, let's go ahead and roll those up at this point in time, and then I can. Is that the only other two? Ms. Rosenwasser will handle the rest?
I believe the only, I think it's those, and then I'm handling the one about the duplicative. And
yes,
I'm sure I can.
We'll push that till tomorrow, along with the other ones related as it relates to you. But just so we handle the ones involving Mr. Floyd this evening. So, sir, if you could go ahead and continue with that.
Okay. Well, I think Mr. Menendez may want to make his argument first.
All right.
Yes, I'm prepared to respond to both.
So you're going to do the motion to sever?
Yes, sir.
Okay. And that's just his, not the counts, just the severance, right?
I was going to do both.
Okay, you can do, okay, so that's, you'll do the motion to sever counts and the trial, and then the unconstitutionality of the gang statute?
RICO statute.
RICO statute, okay, all right.
And Your Honor, I can take the gang statute, or I believe Mr. Carlson was interested in that one, but if he's...
And 418, yeah, you can, okay, that's fine, that's fine. Okay, all right. Okay, Mr. Menendez, go ahead, sir.
Yes, thank you, Judge. As far as severing counts, what I'm asking here, Your Honor, for Mr. Farley is to sever his trial into count 1, the RICO count, and then another trial that has the other counts that he's alleged to be in, which is 49, 50, 51, and 54. So, Your Honor, Johnson states that pretty clearly that when 2 or more crimes of the same or general nature are committed against different persons at different times and places, and they're charged in separate counts of an indictment, severance is mandatory upon the defendant's motion if the crimes are joined solely because of their same or similar character. Your Honor, that's Johnson v. State, 364 Georgia Ave. 543. That's from 2022. It goes on to say that if the offenses are not joined solely because they're the same or similar character, and evidence of one charged offense would be admissible as a similar transaction during trial on another charged offense, the trial court's vested with discretion in deciding whether to grant the motion to sever. So there's nothing commanding Your Honor to do it one way or the other, but I am asking Your Honor to do that because the court does go on to say in that case that in making this decision, the court must consider the number of offenses, the complexity of the charges, that's crucial, and the complexity of the evidence, and determine whether a jury will be able to fairly and intelligently parse the evidence and apply the law. So here, Your Honor, we have a completely unfair trial as it counts to the murder counts, because here what we have, if he were tried just on the murder counts, we have a person who's an entrepreneur, networking, and finds himself riding in the backseat of a car that's behind another car, and then something happens where we don't know the circumstances. So, Your Honor, that's a very different kind of trial than me having to fight that on its own versus me having to fight that now with all these people and all these attorneys and all this evidence of RICO going back to 2013, 2015, wiretaps, all this stuff, just to simply decide whether sitting in the backseat of a car makes you a party to a murder when there's no other assistance alleged and he's merely present, merely associated. And so, Your Honor, to get up here and then you're going to tell the jury, oh, mere association doesn't count on these counts, but then here's a whole RICO case where the entire nature of the case is association, which is okay. I mean, I disagree with RICO, as we'll find out from our other motion, but
to do a RICO count and then these murder counts together is just, not fair, Your Honor. And they are joined solely because they're the same and similar character. So that's that, Your Honor. I mean, there is nothing. There's the murder of Mr. Schmeldrinks, and then the jury's analysis of the burden of proof on that is going to be just completely confused by the complexity of the other case. And then it really is just this presence and this association that ties him into the RICO. So under Johnson, Your Honor, I'm just asking this court to sever count 1 from the rest of the counts just for Mr. Farley.
All right. Go ahead and argue the rest of the, that's your motion to sever counts. What about the trial? And then you can deal with the gang statute, your argument on the gang statute and the RICO statute.
Yes, Judge. So admittedly, this motion to sever the trials is a lot stronger. And I do think it's less discretionary and leads, if we don't sever it, to a situation where Mr. Farley's rights are just completely trashed. So, for example, the biggest reason, Your Honor, is because there's so much evidence admitted against one co-defendant that wouldn't be admitted against him. Okay, but what I think is the strongest argument, Your Honor, is just the scale of this. We've had all these pretrial hearings about how it's going to take 6 to 9 months. And so, Your Honor, to have a defendant like Mr. Farley, who doesn't have the resources like some of the other defendants, who we now see still don't have an attorney, Your Honor. So I think the proof is right behind me how difficult it is for someone to hire an attorney of their choosing, free of conflict, which is his right under the Sixth Amendment. He has a right under the Sixth Amendment to an attorney of his choosing, free of conflict. Had it not been for me agreeing to do the case, that would be impossible. And that's impossible for a lot of the co-defendants, Your Honor. We've seen that. When you try 28 people at once, you're like taking up all the private attorneys of the city that you live in, and you're asking that private attorney who has had to go through years of training, hundreds of thousands of dollars of education, and now these clients essentially rent us out for their advocacy. And that's just not fair, Your Honor. It's like, oh, you're going to go to the prom, we're going to rent you a limo, but now, oh, actually, this prom is going to last 6 to 9 months, and you're going to have to rent a limo every single day. You're going to have to rent out Mr. Menendez to sit there with you every day and pay him by the hour. That's not fair. It's not fair, Judge. So that will be solved by severing the trial of Mr. Farley. That might be fair to some other defendants who are all over the discovery, but Mr. Farley, he's only in like 7 out of the 191 overt acts, and he's only in 4 of the counts. So in that 6 to 9 months, my actual engagement in his advocacy will be a matter of days. It's something we can do in a week and a half. But what the state has done to rob him of his rights under the Sixth Amendment and his rights to due process and his right to be treated equally and not be discriminated against based on wealth or anything else, they've put 28 people together, and then for those people that are in such a small part of the discovery, they've created a situation where you don't get to pick your attorney. You just get to hope that you'll have someone agree to something, even though it might not make sense. And now, look what we have. We have people who are still unable to hire an attorney. And I think part of it is because of this lack of severance. And so, Judge, to force Mr. Farley to sit there with a paid advocate who's not going to do anything for months at a time is not fair, Your Honor. They're essentially picking his attorney for him by saying, oh, you got to have this amount of money or otherwise you can't defend yourself, which is not fair because what he only needs is someone to defend him for a few weeks. And this RICO count, they could easily just prove just those overt acts and the existence of a conspiracy. It's not going to take a long time. They're going to say, oh, they're going to make us redo this RICO conspiracy over and over and over. No, they just got to show what they say is seemingly based on the rulings of my other motions. It's not that hard. A nexus, a few overt acts, a pattern, and that's it. That can be done with this handful of witnesses in addition to his other counts, Judge, but that should be separate. That way it can be done in like a week and a half, and that way Mr. Farley isn't forced to defend himself in the way that he has to resort to because of money and because of this sort of wealth discrimination of accusing this many people at once of something, Your Honor. And so I included other arguments, of course, but those have been articulated by other co-defendants in the past. It's more just for the record. But I do cite some things like Morris v. State, whenever it appears necessary to determine a fair determination of the guilt or innocence of a defendant. To have a fair determination of that, Your Honor, Mr. Farley should have his trial severed so that it can be just a week and a half, and then he can have an attorney of his choosing, free of conflict, and he can have his due process and his confrontation under the Fifth and the Sixth Amendments.
Okay, let's move on to now the your argument in terms of the gang statute, unconstitutionality, as well as the RICO statute.
Yes, which one do you want, Your Honor? I'm doing RICO. Ms. Rosenwasser is doing gang.
Okay, let's see then. I will table Ms. Rosenwasser's one till tomorrow. She's doing the gang statute? Madam?
Yes,
Is that what you're doing? Okay, all right.
I'm sorry to interrupt.
That's okay. No, that's fine, sir. Okay, then you're doing unconstitutionality RICO.
Yes, sir.
All right, handle that for me, please. Let's do that tonight.
Yes, Judge. Things don't change until they get challenged. Our country has a long history of case law that then realizes, oh, this was wrong, and it just takes someone doing the right thing and challenging that for that determination to even go up to a higher court, Your Honor. So that's why I am objecting to these. Your Honor, just because something has been deemed constitutional in the past just doesn't mean that it is, and I think this case specifically.
What's your basis to have for me as the trial judge in this case to have it declared or unconstitutional? Hasn't our Supreme Court already passed on this issue?
Not as it pertains to this exact set of facts. That's why this is distinguishable, Judge. One, the scope of it and the financial aspect, but also the First Amendment aspect. We have several overt acts here that involve artistry, just entrepreneurship, clothing, and that's an unconstitutional application of finding someone accountable criminally for something.
Well, I think the state's argument is when those acts, and this is what I guess we'll find out at trial, whether or not those acts are basically admissions. So
exactly, Your Honor.
So that's something we'll take up at trial.
Yes, Judge. And I of course, I don't expect the court to rule in my favor on this, but I do want to have it for the record. And you never know, this is a chance to do something cool. And I think it is the right thing, Your Honor. The vagueness as well of the RICO statute.
Well, you have to have a good faith basis to challenge the statute. So I think you've raised one. If you're saying that is the issue of the interplay between the First Amendment and clothing, some other things. Yes, that is fine. Yeah. And you certainly are well within your rights, and you wouldn't be a good advocate if you weren't doing that on behalf of your client, okay?
Yes, Judge. And just real quick for the record, the other things I put in my motion were the fact that they're able to put so much evidence in the indictment itself is unconstitutional. We don't get to do that for any other allegation. There's social media pictures in the indictment. Your Honor is going to read the indictment to the jury, and they're going to see actual evidence before they even get to the opening statements. That's not how it's supposed to work, Your Honor.
Well, I'm going to read it. But actually, I'm going to tape it. So, and I don't plan on showing the picture. So.
Yes, Judge. And then lastly, we don't have any mechanism here like we do in civil law to have a motion for summary judgment, which is a type of thing I think would have been granted for Mr. Farley here, because not only is the indictment doesn't allege anything, the discovery itself and the warrant affidavit itself for his arrest simply alleges presence and association. So there's nothing stopping the state when they're out to get somebody. They can just, in bad faith, with a warrant that doesn't say anything about how you're a party, just loop you into a big RICO case and then start pressuring you to cooperate or take some kind of deal, because what else are you going to do? But there is no mechanism pre-trial to have Your Honor look at any of that, and so that's another aspect. Well, I can't suppress the whole case, Judge. I can only suppress.
I know, but as it pertains to your client, you filed some 23 motions. I think you're doing a fine job.
Well, thank you, Judge.
Okay. Anything else? Relates to unconstitutionality.
No, Your Honor, that's all.
That was
Okay,
good.
all right.
Hold on. The judge just showed some love. That was the first time he ain't been an asshole, but that nigga said, you doing good. I told y'all, one in the chat if this young kid is good. That's his thugger homeboy right there, lawyer, Mr. Farley. That's the old boy with the light skin dude right there. One in the chat if he dope. 2 in the chat if he trash. Let me know. Let me see. That nigga that was kind of a compliment. It won't even know funny shit. You know what I'm saying? He was like, yeah, you on your shit. You filing all the motions you want it, nigga. That's okay. He recognized that. You feel me?
Thank you, sir. All right, Mr. Floyd.
Thank you,
I
Your
think
Honor.
he's got, a motion to sever the counts, sever the trial, and unconstitutionality of the RICO statute.
Yes,
and
Your Honor.
I'll let Ms. Rosenwasser tomorrow cover the duplicative count issue as well as the gang statute, and I think she said Mr. Carlson will come in and argue the evidence 418 issue.
Mm-hmm.
Okay?
Yes.
Yes, sir. Ms. Johnson.
Response would just like to join in Mr. Menendez's motions with regards to the sentence of the count and the trial itself.
That's fine. Okay. All right. And Mr. Floyd,
Yes, sir.
Whatever the ruling is, can I ask you to prepare an order on whatever grounds on the issues that I've denied? You prepare suitable
1 through 6, the amended special general. Yes, sir.
All right,
Will do.
Let me rule on these things first, and then I'll let you. Depending how I rule on these, I may ask you to include these. Okay.
Whatever the court's pleasure is.
Okay.
Yes.
All right, sir.
So severance. Your Honor has already heard severance motions, I believe 7 of them.
I have.
You have already denied them all.
Yes.
I had a feeling you'd remember, but just in case, I wanted to remind you. The mistaken premise, and it's been true throughout them all and is true here, is the idea that somehow if you sever, the trial becomes much smaller, shorter, easier, a week or whatever. Unfortunately, it doesn't work that way. This is a conspiracy case. We're going to have to prove the enterprise. We're going to have to prove the overt acts, and the evidence is largely the same. I can't say it's exactly the same. I won't go that far, but it will be substantially the same in each circumstance. And so there's not that time efficiency that keeps getting rolled out in front of you simply doesn't exist. That's the primary reason why, and we've cited these cases previously, I haven't been able to find a reported Georgia RICO case where severance was granted and the issue came up in appeal. I just haven't seen it. Every one of them, the posture is severance has been denied. The court looks at it, the appellate court looks at it, says it's a matter of discretion, and discretion was appropriately exercised. And those cases are very similar to this one. We've also cited to you on the same principle an extensive number of federal RICO conspiracy cases. I'm dealing specifically with RICO conspiracy because the question is the same and the standard is essentially the same. The problems that we've mentioned in the past, inefficiency, the trauma of causing individuals to testify repeatedly to violent acts they've suffered, the opportunities for witnesses to shape their testimony in subsequent trials, all of those considerations, that's not the entire list, but we've briefed it extensively in the past. They don't go away. They would actually only get worse if Mr. Farley was to have 2 trials, one on RICO and one on murder, etc. That doesn't solve the problem. It really magnifies it. I think part of Mr. Farley's constitutional arguments drifted over into the severance side, or perhaps he feels they're applicable to both. It doesn't make any difference here because he was talking about Sixth Amendment issues. Mr. Farley has an attorney, and that's Mr. Menendez. Mr. Menendez has, as you pointed out, filed a very extensive list of motions on his behalf and is fighting for him as hard as he possibly can, as we would all expect him to do. But part of what comes with that is Mr. Farley doesn't have standing to raise constitutional issues relating to other people who don't have counsel for whatever reason. He can raise his own. He could raise it if he didn't have counsel, couldn't obtain it, but that's not the situation. And therefore, that's just not an argument that's available to him. As far as constitutionality is concerned, let me first address vagueness. There are quite literally hundreds of RICO challenges based on vagueness. None have succeeded. There are hundreds in the federal system. There's approximately a half dozen, I believe, in our system. And the counterpart state RICO statutes across the country, there's about another 35 or 36 of them. Many of those have been challenged. Vagueness has not worked once. Vagueness didn't work in the Rodriguez case against our gang statute either, for essentially the same reasons, because the statutes have a lot of similarities. There's nothing new here presented on vagueness that hasn't been addressed in the past. In fact, there's nothing really specific at all presented on vagueness. As to First Amendment, it just conflates the problem. The argument that keeps, or the statement that keeps getting presented to the court, is that speech has been criminalized. That's not what we're talking about. We are talking about speech as evidence. There's no offense that says somebody's not being charged with making an offensive lyric or video. That crime doesn't exist in Georgia. It is not alleged in this indictment. But the fact that somebody is engaged in some sort of performance doesn't immunize them and doesn't create a First Amendment shield against all responsibility. I've not been able to find a case that said that a charge is unconstitutional or a statute is unconstitutional because some sort of performance is involved. And frankly, that wouldn't be a basis to hold the statute unconstitutional. It would be a basis to exclude a specific piece of evidence. I imagine that's an argument we're going to get to pretty soon, but that's not a constitutional argument here. The United States Supreme Court in Wisconsin versus Mitchell made it absolutely clear that something doesn't stop being evidence because it's in a book or a movie or a poem or a song or a diary. Because that would lead us to the absurd circumstance in which a person who simply picked up the phone and called the police and said, I murdered John Smith. I did it in this place. I did it on this day. I did it for this reason, and I did it using this weapon. You can go find his body right now. Well, we pretty much know what's going to happen there, right? But if I post it on YouTube and I sing it, that becomes inadmissible. And if we use it to charge, the statute becomes unconstitutional. There's nothing, absolutely nothing that supports that. The too much evidence in the indictment, this is exactly what I was alluding to before, which is the argument that the sort of Goldilocks argument the state usually faces. It's either too much or it's too little. It's never just right. But, you know, this is the same defendant who 30 minutes ago was arguing that we hadn't given the dictionary definition of various phrases in it, and now says, but wait, this statute's unconstitutional because you can talk about too much. Those two things can't occupy the same place at the same time. As I said, I am not aware of any case anywhere in the country holding any RICO statute unconstitutional on any of these grounds. Don't think this should be the first one.
Okay. All right. As it pertains to the amended motion to sever counts, I'm going to deny that motion as it relates to Mr. Farley. I'm also going to deny the motion to sever his trial from the other co-defendants. And I'm also going to deny the motion to declare the Georgia RICO statute unconstitutional. No love. Mr. Menendez, we will take up there's three things I think we'll take up tomorrow as it relates to Mr. Farley: the duplicative counts and the unconstitutionality of the 418 and the gang statute tomorrow. So I'll take up those. I've otherwise, the other issues, as I've indicated, we'll table those until such time as, like for the autopsy photographs and the music video and social media evidence, okay?
Yes, Judge. the evidentiary motions for 28th.
You've got 3, yeah, we will take up those on the 28th. Yeah.
Yeah. Yes, Your Honor. Our witnesses would be available on the 28th. So.
Yeah, but those are only the 3 for those 3 motions, right?
Yes, Your Honor.
Okay, all right. So we'll take up those then. All right. In the waning hours of the day, let me just recap, Ms. Rosenwasser, for tomorrow. You've got Walter Pineda.
Yes, Your Honor. He'll be coming first.
You got Quentin Hall.
Yes, Your Honor.
Okay. Do you have anybody else that potentially you might be able to move up, or might be depending upon how we go tomorrow?
Not to my knowledge. I'll reach out to Investigator Worrell tonight. He was one of the people on for Wednesday. I can see if he's available. But we do have Mr. Stillwell's motion to dismiss. We should be able to do that. I know the court wished to hear that tomorrow as well.
Okay, all right.
And then obviously I'll be ready for Mr. Farley's motions also. The 2 that we just talked about.
All right, I think that's plenty. And then there'll be some, I'm sure that, folks, just to put you on notice, Thursday we will have to take up the issues involving the jury questionnaire. So what I'd like you to do is prepare for we have a list of the questions that we propose to ask. What I'm asking you all to do is, if you have a specific objection to a question.
Why this nigga look like a bootlegged Uncle Phil? Rest in peace, Uncle Phil. And he was a judge too on Fresh Prince. Tell me this nigga don't like Uncle Phil, goddamn brother from goddamn Detroit or some guy shit. What the fuck? This nigga like motherfucking Uncle Phil. That shit just hit me, bro. Ain't no way, boy. Ain't no fucking way.
Question that the court is going to put in the questionnaire. You come prepared to argue those on Thursday morning. I'm not going to go through all of them unless I absolutely have to in that respect. But we've had plenty of time at this point in time to kind of consider that. So Thursday morning we'll take up that issue. Is there anything else I need to kind of, as an administrative announcement I need to do? Sure. Mr. Floyd, you'll take care of a suitable order. Send that to Mr. Menendez.
I will do that. And, Your Honor, I just want to ask one question to the format. There were 6 amended special and general demurrers, and they were filed each as a separate document, as you saw. Would the court prefer a separate order as to each one, or is it okay to consolidate?
It's okay to consolidate that. Yes, sir.
All right. Thank you.
All right. Yes, Mr. Adams.
Perhaps I've missed it. Has the court sent out a proposed list of jury questions? I know we've submitted them, some other attorneys have submitted them, the state has submitted them. Is there a court?
What I'll do is I will ask Mr. Kearns is not feeling well, so I'm going to ask him tomorrow if that hasn't been sent out already. It should be sent out. Okay? All right.
So, Your Honor, we will have that questionnaire prior to Thursday.
Yep. If you haven't otherwise, if you've submitted questions, then that's fine. But yes, I'll ask Mr. Kearns about that tomorrow. And we'll hopefully get it out tomorrow sometime. I think he's been working on it. I've seen some of it, so we should be good in that respect, okay? All right. Anything else in terms of administrative announcements?
No, Your Honor.
All right, well then we'll see you all tomorrow morning for anticipated start time about 9:30, okay?
Yes, sir.
Thank you.
Okay, all right, we're in recess.
I'll get with you.
Well, damn. Well, damn. Damn, Thugger. And that was all for his co-defendant, you know. Thug was talking yesterday though, you know what I'm saying? But I guess they was dedicating that session to his homie or his co-defendant or whatever. But what y'all think, man? What y'all think about it, bro? Hey, look, little dude lawyer was fighting though. You know what I'm saying? Little dude lawyer was fighting. I ain't gonna cap. Little dude lawyer was fighting, bro. I ain't gonna cap, bro. Where everybody from in this motherfucker, man? We hit, I think the highest we hit was 7,400 viewers, man. Where everybody from? What city, state, what countries? Where y'all from in this motherfucker, man? Thugger. Where motherfucking my nigga Thugger though? Not my nigga Thugger though. I will play the video, but they gon' shit on us. Y'all know that. Matter of fact, how about digits? I think we can play digits. I played digits one time for Thugger, man. Greece, hold on, Duval County, St. Lucia, Seattle, D.C., Arkansas, Stockton, North Korea, Finland, Oakland, Brooklyn. We got Kodak, Cincy, Houston, Dade County, Free Thugger, India, Savannah, Memphis. Shout out M-Town, Cleveland, Florida. What that? Lafayette, ATL, North Carolina, Stone Mountain. What's happening? Stone Mountain, Toronto, Canada, North Cat. What's happening? Grenada. What's happening? NC, Liberia. Y'all got this shit in Liberia, nigga? I guess so, man. Shout out everybody here. Smash that motherfucking like, gang. Jacksonville, Jersey, North Korea, Grenada, Australia, UK, New Zealand, Arkansas, OKC, B-More, what up? Mississippi, New York, Arizona, Jamaica, Wagwan. Thucker. Bitch. Huh? Come on, man. You gotta show Thug some love, man. He did innovate some shit now. He did innovate the game for the young niggas though. I can't cap. He came out when I was in prison. See, I was in prison when Thug dropped, so I ain't know what the nigga looked like. I just heard, I'm a stoner. And I was a fucking stoner, so that was my shit. Brazil, Philly, Milwaukee, Louisville, Detroit, Holland, Cleveland. Put them free thuggers in the chat, man. Free thugger in the chat, man. We got London on the track. Free thugger in the chat only.
Nigga, horses don't stop. They keep going. You can lose your life, but it gon' keep going. Why not risk life when it's gon' keep going? When you die, somebody else was born, but at least we got to say we ran on the digit, we ran on the money, we ran on the digit, we ran on that money, we ran on the digit, we ran on that money. We ran on the digit, we ran on some money, we ran on the digit, we ran on some money, we ran on some digit, we ran on some money. I'm leaning like I'm on the field for the Hennies. I talk lots of shit like my bitches are dangerous. They didn't know me once, so I left from with wishes. You know it's a drop when you drain and can't flip it. I'm living big, I swear to God, on Luke ain't kidding.
Free thugging only in the chat. Free thuggers.
You know my ice blinking like Roche, like
flood the chat. Free thuggers spam.
My racks are squeaking on that pot and I hop in that Rari. I crank on like water. Horses don't stop, they keep going. You can lose your life, but it gon' keep going. Why not risk life when it's gon' keep going? Yeah. When you die, somebody else was born, but at least we got to say we ran on the digit, we ran on the money, we ran on the digit, we ran on that money, we ran on the digit, we ran on that money. We ran on the digit, we ran on the money, we ran on the digit, we ran on some money, we ran on some digit, we ran on some money.
Hey, this motivation right here.
I'ma move me so no like confusion. I'ma go in that bitch with a ruler. I'ma toast me a nigga like Schroeder's. I'ma keep a red flag on a booler. I know some roller spaces like a duelist. Yeah, I'm screaming on my car like Buddha. When I snort it, I feel like I was aborted. If I ever ordained it, baby, you better drop what's for. I been getting money before the music for Pandora. I just do this shit when I get bored. Nigga, horses don't stop, they keep going. You can lose your life, but it gon' keep going. Why not risk life when it's gon' keep going? When you die, somebody else was born, but at least we got to say we ran on the digit, we ran on the money, we ran on the digit, we ran on that money, we ran on the digit, we ran on that money. We ran on the digit, we ran on some money, we ran on the digit, we ran on some money, we ran on some digit, we ran on some money. We got London on the track.
Free thug, man. It was a good run. They had a good run, man. They had a good fucking run, bro. They had a good run, man. Damn, they had a good run. Damn, them niggas had a good ass run, bro. You said play it. I don't want to play it back. See, I only played that because it's not gonna get blocked on YouTube. They be on that bullshit on YouTube and shit. I'm gonna see. Let me see something. I'm gonna do Thugger Best Friend Live. Since I can't play the video, I'm gonna click on whatever the first live one. I'll play that. Why sell for life, bitch? Fuck you, your mama, and everybody. This one should be good. It's gonna be copyrighted, but I don't think it should get blocked though. Hopefully not. Smash them likes, my nigga. Smash them mics, man. Free thug. They had a good run, bro. It was a good run. You can't deny it. They had a good run. It's even if he get free, it's not gonna be the same. Nothing's gonna ever be you know what I'm saying? It was a good run, bro. They had a good little run. 10-year run. They had a 10-year run, you know what I'm saying? They had a good 10-year run. From nothing to something, you know what I mean? They was on the billboards last year this time.
Friend, where yours at?
Why sell for life, bitch? Yeah, fuck you. TM88. Shout out 808 Mafia. Shout out YK808.
Free to go. That's my best friend. That's my best friend. Big old booty bitch message from Texas. Whoa. I'm a skeet all the nigga gon' catch me. And that's my best and my best and my best friend. Nigga limit TTG and everything is still on me. Whoa! That bitch rolling with me, she gon' smile and she on me. Whoa! $100,000, I might pay my shit on me. Let go!
I ain't counting them out. I'm just saying. The click is broken up.
Whoa! Swagger! Bitch, I'm bleeding back. Like what? Like hold up! Nigga! Huh? He that booty, just like turn up! You know that booty. Let that bitch out, let it do it. No type of bitch in that woody, that wood. Supply your bitch, I got pistols on wood. I want tacos that'll make it. Helicopter chopping with the bug. Stuck the rice inside the middle, man, that other side, nigga, curve. And my river louder than the speaker. Yeah, my niece is hanging with the beef. If you ever find a better keep 37 cameras for the sneaks. Going out like awesome in the city. Send a cop, I can't wait in the street. Forcing your hoe, I can't wait to mislead. Bitch. Turn up! That's my best friend. Big ol' booty bitch message from Texas. Whoa! I'm a skeet all the nigga gon' catch you. That's my best and my best and my best friend.
One more time!
Nigga limit TTG and everything is still on. Baby rolling with me, she gon' smile cause she on.
You ready, sir?
$100,000,
now turn the fuck up!
Let me tell you how I spent a couple. Whoa! I done cut back on and lean on money. Whoa! Don't do no talking when you see you better shoot in the face. I got 100 bitches, I can't wait to replay. Mike Jackson, nigga, Gus Jackson. Whoa! Stop burning. Whoa! Be 100 cold, I'm pulling at the pools. Bitch, I'm pulling. No, I can't get arrested. Cause I'm talking about my turn up, put that bitch in the car. I'm a dog. Let's get mother, sister, bro. Be lucky, chama, give me. What up, cut in your car? Come on, what? Where my book? Yo, what's up? Don't have pause. See that drug. One more time. That's my best friend, that's my best friend. Big ol' booty, bitch message from Texas with Nexus. I'm a skeet all the nigga gon' catch you. And that's my best and my best and my best friend. One more time. Nigga living TTG and everything is still on. Baby rolling with me, she gon' smile and she on. $100,000, one more time. One more time.
Man, It was a good run, man. I appreciate everybody pulled up, man. I ain't had a drink of water, ate nothing today. I got to go handle that, man. Get my motherfucking mind right, man. I'll pop back in later, something. I don't know, man. Gang, no gang, no gang.